Good evening. Welcome to our LPA meeting on January the 8th. We'll get started here with the roll call, please.
Cheryl Culberson. Patrick Foley. Tony Hammond.
Present.
Susan Raffanello.
Here.
James Ryan.
Present.
Vice Chair Lori Lalonde.
Present.
And Chair Deb Gillis.
Here.
We have
We have more than a quorum. We have everybody here tonight. Yay! It's always a fun night with everybody. Next in order is the pledge. Sue, could you lead us, please? Okay, moving right along here. Request for additions and emergency additions and deletions. Yes?
Want to note that you received an email from the applicant for letters G and H on your agenda, asking that they be postponed.
Okay, help me remember that when we get there. Anything else? Anybody else?
Nope.
Okay, hearing none, moving on. Okay, it's time for general public comment. This is time to speak on anything that's not on the agenda this evening, and you have 3 minutes. Do I have anybody signed up for general comment?
We have Van Cadenhead.
Good afternoon, ladies and gentlemen. Nice to see you all here. All of you here. That's really a good thing. We're going to be talking about a lot of very influential projects this evening, and I wish us the best. I'm hoping that we can have a peaceful year this year, because last year was a little bit tumultuous, to understate it. And once again, I'm still trying to save that tree, and I'm still seeing a lot of impetus to put 20 feet of cotton in a 10-foot sack. And I really hope that you will resist that in your deliberations and in your conduct for the coming year, because Islamorada has been overbuilt. And we're not getting any help from Florida Commerce as far as trying to uphold the state of critical concern, because they're not too concerned about it. They're more concerned about the increase of ad valorem taxes, and that's not helping the people of Islamorada or the environment of Islamorada or the Florida Keys in general. So I hope you can pull back on the reins a little bit this year, and I'll be here and as long as I can stand it. And it's just it's heart-wrenching to watch what's going on in this town, as far as everybody trying to squeeze everything to the property line and push everything to the utmost boundary of any project that comes forward. So I hope that you can pull in the reins a little bit on that and what you recommend to the council, because they need some guidance. Thank you very much.
Thank you. Anybody else? Anybody on Zoom?
Mm-mm.
Nope.
No one else.
All right. Public comment is closed then. The consent agenda is the minutes from our last meeting in December. I actually have a question. I think it's a correction. On the vote on approving the last set of minutes, it says 5-1, and Patrick abstained. I think it should be 5-0. with one abstention.
I put the abstain as a no.
I,
Okay, I need to change that.
yes, please. Thank you. Anybody else see anything that, with that correction, do I have a motion to approve?
Motion to approve is presented.
Second.
All in favor?
Aye.
Aye.
Who was the second?
Tony. Okay, moving into the regular agenda, we have several public hearings tonight. And the first one, tab A. Mr. Attorney, welcome back from vacation, and could you read the title?
Thank you, and I Happy New Year to everybody, and I hope you all, I haven't seen you all in a while because Allison and Roger were here for the training session, so Happy New Year. I hope everyone had a good time. First is an ordinance of Isla Mirada, Village of Islands, Florida, amending Chapter 30, Land Development Regulations, Article 4, Administrative Procedures, Division 2, Development Review Process, Section 30-212 of the Village Code to create a review for the imposition of certain conditions, providing for severability, providing for inclusion in the code, and providing for an effective date.
And are you doing this or Jennifer?
I can do this. This was something that was proposed from my office. This relates to kind of just additional protections for the village when it comes to possible takings claims, that if someone feels that there is an exaction or a condition that does not meet a public purpose, that it allows for an additional step, an additional administrative step for that person to take, that they can challenge that to the village council, and the village council will be the final arbiter of that. It provides basically the village one additional opportunity to look at the condition to make sure we got it right. It also, if anybody tries to skip that step and go straight to court, it gives us an additional defense. There's a defense called failure to exhaust administrative remedies, which means you had some additional processes that you could have gone through to try to correct this. Courts will generally dismiss that for failure to exhaust that. So it just gives us some additional protections for possible takings claims.
Okay. Any comments? Sure.
What is the trigger for there's generally a 30-day time frame to exhaust administrative remedies, correct?
Well, it depends on your code. I mean, it depends on how much time you have to exhaust. But yes, in the village code, there's usually a 30-day period to appeal something.
And when this is done for the takings claims, what would be the trigger to start that time frame ticking such that this would be an additional protection?
Well, it would be the imposition of any sort of condition. So if there's a condition that, say, some sort of mitigation condition that, yes, we'll approve this, but you need to put up an additional buffer hedge or something like that to stop the noise. If somebody felt that was an exaction or did not meet a public purpose, then they could appeal that process. They could appeal that to the village council.
So we're conditioned, I guess, in Isla Mirada, in part to think of the quote-unquote takings claims or the Burt-Harris claims, if you will, as conditioned to the running out of building allocations, excuse me.
Yeah, this would be different from a BPAS takings.
So this isn't, when you say this is additional protection from the BPAS, I just want to understand, for the takings claims, BPAS itself doesn't have a trigger where that will start a time clock ticking such that this would be an administrative remedy, that if you don't follow it in 30 days, you'd be forever barred.
Yeah, this is for when you impose conditions upon the development. This doesn't relate to. There's different avenues that people could allege takings. One of them, we'll talk about. I think there's defenses too, but we've at least heard talk about people raising it with regard to BPAS or not getting BPAS allocations. That this would not apply to that. This would apply to a different subset when we're talking about development conditions.
Okay, I just wanted to make sure I understood that.
Okay, and she's referring to the time frame. Is it, I didn't happen to see it in here. Is that written in another part of the code? Or does it need to be added?
I'll have to look and confirm what the time period is. I'll double check as to where that provision is. I don't think it's in this section, but I'll double check in terms of
Make sure
administrative
it's
appeals.
what we need.
Yeah, general administrative appeals. Let me see if I can find that while you all are talking.
Okay. Anybody else have a question?
The only thing I flagged was where it says the village council should be the final arbiter. I just know how flexible that can be and how difficult that can be. Just comment on that, if you would, please.
Yeah, well, that's just to make sure that it's clear as to who the final decision maker is for the administrative process. It's not your planning director, it's not your manager, it's not, I don't know who else would fall in that line, the village attorney. The appeal is to the village council, and they are the ones who are making the final decision. So if we ever get to a point where we have to argue the exhaustion of administrative remedies, it's clear as to what the path is, who the decision maker is, and we can point to they have not followed that process, or if they have, then they have. It's clear as to who that decision maker is to end that process.
Did that answer your question?
But does that not, in a way, this is designed to add a step for an administrative remedy? So as you say, if there's later litigation, you can say you didn't exhaust an administrative remedy, but it also gives an administrative remedy where none exists. So currently, if they just went to court, it would be determined by a judge whether there's a nexus to policy or not policy, great. But if it goes to the village council, piggybacking on Tony's perhaps thought process, now we're all up in the air again.
Yeah, well, we don't currently have
It's at the whim of the council.
Well, it gives the council the additional ability to look at something and give it a second look. But yes, ultimately it would be by vote of the council. But if the council sees this, and if we look at this and say, you know what, the arguments they're making might have some merit, or they don't, we can advise the council, and the council would be the final arbiter. And that's, otherwise, right now it goes, your planning director makes a determination. It may or may not, depending on what the application is, it may or may not go before council. So yeah, this is an extra step, gives us the ability, it gives us the protection like I talked about and like you pointed out, but also gives us another bite at the apple to try to make crystal clear that let's just confirm, yes, does this have a public purpose behind this that we can defend it? And just gives us one more step step in the process to do that. And also in terms of the time period, Jennifer found it for me. It's under 30-281. It's 30 days for administrative appeals.
Standard.
Okay. Any other questions? James, you have something?
Yeah, John, do you think you could give me, so I understand it creates the protection, but now I'm seeing where it also creates that avenue. Could I just get like one more example of, I guess, the way this would be utilized?
Yeah, I mean, it's really just going to be for a condition. I mean, Jennifer, can you think of if they had thought of buffer conditions, there might be parking conditions that are placed on it. There might be noise restriction conditions that could be placed upon, like if you have an outdoor venue, then it's a bar that's, it's zoned, but, or there might be some sort of noise condition that, no noise after a certain period, that's different than.
Like we just, not just, but this past year, we granted an outdoor seating permit to a business, and one of the conditions was that they couldn't have any outdoor music. So like that could be a condition that if they had at that time decided, hey, that's really not fair or not, a nexus to what we're trying to do here, we want to appeal that condition. They didn't, but that could be something that they could have appealed.
Okay.
And as it stands now, as Ms. Raffanella pointed out, if they feel that it doesn't have a nexus or it doesn't have a public purpose or is an exaction, they could go straight to court, and then we're in that procedure. This just gives us another step in the process to try to just double check and then make sure that also gives us additional defense if they don't follow the procedure properly.
There's still that opportunity, though, if they don't, let's say, like the response from village council, that they go to court still.
Yeah, oh yeah,
Okay.
if it still doesn't work out and they still believe that it's improper or taking, they still have the avenue to continue pursuing it.
Lori, you got anything?
No, fine.
You said no, you said no. Public comment? Any public comment on this one?
I don't have anyone signed up.
And nothing on Zoom, right?
No.
Okay, all right. We're ready for a motion.
Motion to approve is presented.
And a second?
I'll second.
Roll call?
Cheryl Culberson,
Yes.
Tony Hammond,
Yes.
Patrick Foley, Vice Chair Lori Lalonde,
Yes.
Susan Raffadella,
Yes.
James Ryan,
Yes.
and Chair Deb Gillis.
Yes,
Okay, motion passes 7-0.
thank you. Okay, moving on to tab B.
Tab B is an ordinance of Isla Mirada Village of Islands, Florida, amending Chapter 30, Land Development Regulations, Article 4, Administrative Procedures, Division 4, Building Permit Allocation System, Section 30-475 of the Village Code, to address allocation awards in connection with expired permits, providing for severability, providing for inclusion in the code, providing for the transmittal of this ordinance to the State Department of Commerce, and providing for an effective date upon the approval of this ordinance by the State Department of Commerce.
And who's presenting this one? Don't argue.
We're both being too polite and offering the other a chance to take it. So, yeah. So this arose. We came across a scenario where there is somebody received a BPAS allocation, actually picked up the allocation, but never did anything. The permit has since expired. The current village code does not address that scenario. It addresses what happens if somebody never picks up the permit, but it doesn't address what happens if somebody sits on the permit and does nothing. So this was brought to our attention by the building official. So Sheila, Jennifer, and I got together and we proposed this, this language that creates a new subsection H as to what happens when you have an expired permit. It actually just tracks the same language as what happens when you have an expired allocation, meaning you don't actually pick up the allocation. So basically what it does, it's the same thing. It gets returned to the village and gets put in the administrative relief pool. We got some information, let me see, Jennifer sent it over to me earlier today, the number of permits that this actually impacts. I think it's 5. One has been expired as far back as 2017. And then the earliest one, I think, expired in 2022. So it goes, some of these permits have been, frankly expired and dormant for up to 6 years. So there's 5 properties this would impact, and it would potentially bring back 5 more allocation awards to the village that could be used in administrative relief, since the permit holders apparently are not looking to move forward with it. It should be noted that the dates have been calculated for the expiration based upon emergency orders, because there are a number of emergency orders when we have hurricanes and things like that, that the governor will toll the dates for the expiration periods for permits. So even the one that's been expired since 2022, I mean, you all know we've had a number of hurricanes that have come through, and there have been a number of extension periods or tolling periods that this would deal with. So we're just looking to address this situation that is not dealt with in the code currently. We looked at the county. I know Jennifer reached out to the county. The county has something similar in their code that they address this in effectively the same manner.
So how have you handled this in the past? It's my understanding that anybody who came across a property or purchased a property, a lot that had an expired building right, was able to reactivate the building right. Isn't that correct?
Well, currently that building right just sits out there and they can sit on it. So they could have potentially apply to reactivate it. It would, I don't know how it's been dealt with in the past. In fact, when we talked with Sheila, the building official, my recollection is that she hadn't dealt with this before. So
I think that they have been reactivated because I know a number of them a couple of them that I've been involved with myself in selling property. So, and the other aspect is that they were paid for, correct? It's substantially paid for.
Yeah, they would have paid for the permit, but I mean, at some point, if we have a permit that's been expired for 6 years, at some point, well, almost going 6.5 if it's 2017, people need to move on permits. I mean, you can't just sit on a permit.
I agree what you're saying to a certain extent, but I also understand that sometimes there are extenuating circumstances. Like, for example, if I had one on my lot and I lost my husband, I would have not been able to move forward on the requirements that was necessary in order to keep the permit active. But I could do so now. I'm moving forward 8 years. I could do so. So I think maybe since we're only dealing with 5, maybe there's another solution. Maybe there's an opportunity to say, all right, you 5 people who have these building rights that you've paid for and that have expired, let us know. Are you interested in moving forward, and give them a time certain. Give them 6 months, 8 months. They paid for them. And it wasn't a substantial price that they paid in order to move forward through the whole process.
So there's nothing along that same line. There's nothing that we have currently that tells us why they didn't pick it up. We haven't reached out to them, right? I mean, why they haven't moved forward. We have not reached out to them and said, your permit expired, what's going on, right? There's nothing in code that...
No, we currently, today, have not reached out to them. Sheila and my intention was, after it got through the LPA, to send everybody on the list, the 5 people, a letter explaining, what the process was what we were going through with this process, and inviting them to the first reading at the council meeting for public comment and letting them know what was happening. We also spoke and agreed that we would give everybody on the list a grace period of some kind. We didn't talk about what that looked like yet, but we did speak that would be a good idea. But no, we haven't reached out individually to every single person on this list.
But I guess I'm going to be the flip side. I've never known a municipality that, number one, would reach out. Number two, typically building permits or site plan approvals and so forth have either an 18-month or a 2-year tail. And if you don't have a shovel in the ground or building plans approved by that time, it's going to expire unless you take proactive action in your circumstance to say, I have a circumstance, I need to extend the deadline, and then the staff or the council, as appropriate, takes that up. It's not something that's dead for, going back as far as 5 years, even with extensions, which were a lot, probably about 18 months worth, that the governor had given. So while I don't object to a grace period for those individuals, I also do not hold a lot of concern about implementing a procedure on going forward that says, no, they're going back into the pool, because it's not like you have a month. I don't know what that is. It's not like you have a month. You have, 2 years after you pick up?
180.
6 months?
So
okay.
So first it's 180 days, and then every inspection or activity on that permit adds additional time. So,
but when you get a permit, you already have plans and whatnot. So it's not. So it's not like you're already past what I would consider a site plan approval stage, where you have plans. That's actual to put shovel in the ground, and you have 6 months to do it.
yes.
And as you pointed out, the extensions or the tolling periods were quite lengthy. I don't know the exact number, but 18 months does not sound outside the realm of what I believe it is, or has been.
And just to also say that even if we were to reach out and people say, you know what, I'm not going to build, like, you can have it back, I don't think, and John can correct me if I'm wrong, have a mechanism right now to take these back. So we would need this in place to even take those back if people said, hey, you can have it.
And I totally understand that we have nothing in place to take them back, and even if we did have, where would they go? This spells all that out.
Right.
I was
kind of talking about is that in past history, the process has been, oh yeah, your permit has expired. Okay, not a problem. I'm going to sell my property to you. You have the ability to go in and reactivate the expired permit. So we've kind of already had a precedence of a process that was occurring. And now you're asking, with 5 left, 5 of the situation, to all of a sudden jump ship and go in a different direction.
But that wasn't set out anywhere either, the fact that they would have that ability. So I don't think there's any reliance argument that can be made for that. And the fact of the matter is, if you get a building allocation for your property, you don't act upon it, then you sell your property, nobody is buying it based upon the fact that there's a building permit. You would have to go through and make sure that you could do that somehow. And if you could, and that historically has been done, that's fine. But the people that are currently, this is being addressed for, both future and current ones that exist, haven't done that. And instead, it's just improving a property with basically giving them the potential of a TDR for no, never having had to put shovel in the ground because they played the system correctly. And I think that there's a time that we need to cut that off. And the time would be now when we need the building permits back.
So, okay. I was going to say, I was going to pause for public comment, but that's okay. Go.
I've got a question so that I understand this completely. Currently, when these permits were issued back to 2017, on the permit, having not read mine closely, since I've already built, on the permit, does it describe how long this is good for and what your process is in the event, at the end of the 6 months, it's expired? Is there something on the permit that states that?
I believe so. I don't have a permit in front of me, but I believe it does.
So we would need to modify that language to indicate that there's a time certain that this will not be extended without A, B, C, or D happening. Whatever we decide as a group should happen. But at some point, there needs to be notification. I'm just looking through the whole process of what saves us. So right now, we don't have anything that says, anything other than says this permit expires on 180 days from time of issuance. Is that about correct?
I believe the permit specifies it expires after X amount of days, and then there's when tolling periods come up, I think my recollection is that Sheila updates that in the system, and it's available to the public to access that as to the new expiration dates based upon the emergency order tolling periods.
And if I'm not mistaken, the processes are pretty minimal in terms of those things that you have to do to keep that permit active. If it's drive a piling or pour a header or footer or whatever, and that keeps it active. I can tell you for sure, it says it in the or it did. I don't know, I haven't built anything recently, but it does clearly give you a time frame that you have to operate under. So these have been, I'm trying to understand this. So these, no action has been taken on these permits, and have they been notified your permit is no longer active? You would have to reapply, or what is their status? Are they just out there in limbo?
So they're an expired status. I'd have to go back and speak with the building department. I don't know at what status they notify the permit holder. I do know they notify people in abandoned status. I would assume they would notify them in expired status as well, but I don't want to say that for sure if I don't know that. But
So if it's expired status, then I don't disagree with this at all. Are we simply addressing the fact that this gives us a place to put that expired status, those expired pieces of property? Is that really what we're talking about?
Yeah, it allows us to recapture, I guess, dormant,
Right.
ones that appear to have been expired or abandoned.
I think it's comparable to when we had people not picking up the permits at all. to a degree it is. Well, it is in my mind, okay? So it's, I can see both sides of this, but in trying to explain it, if they didn't pick it up, we created a mechanism for what happens. The allocation expires eventually, okay? With a permit, it expired, but we never did say what would happen or when it would happen. Whether that's, okay, it expires in 6 months, but there's, if you come in within 3 months, you can renew it or you can update it, or we didn't do any of that. I do believe that we need to hold people accountable for the fact that they have a building right and they're not using it. When I was on council and we were doing deferrals, it was because people were struggling there was problems, and we did a deferral to try to help them carry through with what they had and where they were in line, and those were allocations, but somehow in my mind it matches. But I also agree that it can't be ever ending, and if we've had a process of being able to renew a application that has expired, do we actually have a process on file of how to renew?
Yeah, I believe people can send a request to the building official, and she can renew for a period, I believe it's up to 6 months. And that's,
We do have.
it's not, I don't believe it's Isla Mirada code, I believe that's Florida State Building Code.
Oh, well, yeah, but we have to find.
And I was just told by somebody watching that the 30 days prior to expiration, they get a letter saying your permit will expire in 30 days. And then on the day of expiration, they get another letter saying your permit is expired.
Yes, Cheryl?
Yeah, I'm trying, that's all well and good, but I am concerned with the fact that this, especially with the language I'm hearing thrown around, that a permit that's been issued becomes a commodity, a saleable commodity, which is what I'm listening to. Now, the permit that's issued goes with the specific piece of property, correct?
Well, we do have a section in our zoning that allows under transfer of development rights that you can transfer a building permit to another property.
This is not what this says, though. This is said, I gave you a permit for this piece of property.
Correct, but if somebody holds that building permit and they want to transfer it under our transfer of development rights code, they can do that, if it meets all the criteria.
I have a bigger problem with that.
So what do you suppose, there's 5, what do you suppose those individuals that are holding these expired permits, what do they think their property's doing? Do they think?
I've been here for 1 year and I've learned not to suppose anything.
That's a nice attitude. So in other words, are they sitting out there in ignorance thinking, yes, I can just go up there and reactivate my permit? Or are they thinking, nope, permit's dead, I lost it, too bad?
So this is, we're talking about 5 in the past, but if you think about it going forward, is this a good addition? Let's not talk about the 5 in the past right this second. We can make exceptions, we can make whatever for the 5. But going forward, do we tell people, if you allow your permit to expire, you will lose it unless you do X, Y, and Z?
I think you would have to run that across the board. I think that there's the ability to apply for a pool, and the pool permit expires, and you have the ability to reactivate that permit. Am I correct?
We're talking permits that have building permit allocations, so these are single-family homes.
No, I understand that. I understand that. But we're calling it a permit. You're referring to it as a building permit, right? So wouldn't
This
we?
is under the section of our code that refers to the building permit allocation system, so it's only related to those
Just the allocations, okay.
that have allocations.
So essentially, we should be using the term BPAS right now,
Exactly, instead of building permit,
so
because,
that we clarify.
yes,
Okay, so
I agree
it's
with
not a
you.
pool permit.
No. But I was just going to use that as an example, that if you applied for a permit to build a pool and then it expired, you were able to reapply to reactivate it, we would have to do everything across the board the same.
You look at
Well, everything across the board should be the
the
same.
B-Pass?
Oh, sorry.
It is? Okay, good. Don't make me put my glasses.
So if we, at least us, think that going forward, not the 5, going forward, that this is a good addition to recapture building rights that are not being utilized, that they're just sitting out there, then we can notify people as they pick them up, as they expire. You're going to lose this if you don't do something. And we don't have this thing about we don't know why those 5. We don't. So I think we need to think of it as from this day forward, and then we'll figure out those 5 of how to grandfather them in sounds like a bad phrase, but figure out those 5 somehow. At least contact them and see if they have a legitimate reason of why they hadn't done it. Maybe somebody was very sick and didn't get the notices. We all know that notices don't always get delivered. Maybe they don't realize it. Maybe they do. Maybe, who knows? We don't know what those 5 were. Any other comment before I open it for public comment?
Yeah, I have a comment for the attorney. What does the legal term expired mean?
Well, it would be, so expired means that you can no longer act upon it. So after a certain amount of time, whatever that date is, you can no longer act upon it. You would have to, like was talked about with the pool permit, you would reapply, get a new permit, and that way you could act upon it.
This discussion is about expired permits, right?
Correct, just expired permits under the B-Pass system.
Is the answer in the question there? Is the answer in the question there that these are expired permits that are no longer active, and what are we talking about then?
Yeah, they're no longer active, but since there's this B-Pass allocation, the allocation is just hanging out there. It's been assigned to this property, and there's no way for us to recapture it like there is if somebody just fails to pick up the allocation.
But in the past, they've been able to reactivate them, or, there's been no notification. Well, there was notification, sorry. There's been no process for it, right.
We also should probably consider creating the procedure for extenuating circumstances and add that into this. Just exactly.
I think there is.
They adapt a note.
I think there is one for applying for extensions and so forth, already in the code.
We just need to reference it however we need. I just want to make sure it's referenced so that we're not leaving ourselves hanging out there with no way of extending, and it's crystal clear.
Okay, let's open it for public comment, and we can come back and do some more conversation. Anybody?
Yeah, we have 2. Firstly, we have Ty Harris, and then we have Van Cadenhead.
Good evening. Ty Harris, 110 Plantation Shores Drive. I can give you a little institutional knowledge on this since I was the former planning director and there was no ordinance on this. And this actually predates me, goes back to Cheryl Safari. So what we advised people who had paid for the permit, this didn't apply to people that didn't pay for the permit, but if you came in and you paid for your permit, we advised them that your building right was locked in and that if you didn't act on the permit, it went into abandoned status, and that when you pulled it out, you would have to meet whatever the building code is at the time. So if the code changed, which it does regularly, you would have to meet that. And how the situation, from what I could tell, arose is that people would put in what they call off-the-shelf plans. So this isn't necessarily the house I want to build, but it's a set of plans that are tried and true that the village has approved in the past for a standard 3.2, and it will get me in line. So that's what people would do. Their idea may be that they're going to build a 4-3 or something larger or something smaller, but they wanted to get in line, and once they paid for the allocation, that was the advice we gave them. And that predated me, so we were very consistent because there was no section of the code that addressed this in any other way. I know what the county does. The county also exposed themselves to Burt J. Harris cases because of this. I know of one right now that is being looked at because somebody had actually paid for the permit, they were English, then they decided to sell the property. They got a letter saying your permit's about to expire. They didn't call for an inspection for the electric pole, and now the permit's expired, and the prospective purchaser is like, there's no building right. So that has been passed on to another takings law firm that is looking at that, because that there's some very real exposure to the county for that. And if you're going to do anything different than what we've advised people, because if I get deposed, I'm going to tell you exactly, I'm going to tell the court exactly what I'm telling you, and the judges, this is what we told everybody. Your permit doesn't die, it goes into abandoned status, which is why we were different than the county. And you could pull it out, you would have to pay the additional fees for whatever you were proposing to do and to update the code, but once you paid for it, you had locked in that right. So if we're going to change that, and we've been telling people that from at least 2017, which is before I got here, then we need to go with that forward, not try to apply that retroactively. And I've been telling people ever since I left the village that there's no provision in the code, and that this is what happens if your permit goes into abandoned status, that you'll be able to reactivate it as long as you paid for, not insubstantial fees. What are they, $30,000, $35,000 in building permit fees? So that's what people are paying, and we've told them that your permit's locked in. If we're going to change that, then we need to be careful how we do it, and certainly that we're careful how we're applying that, and applying that retroactively could get messy quickly.
I have a question for you, Ty. Hang on a minute.
Yeah.
You said you were telling them that it went into abandoned status. So you're saying, tell me if I'm hearing this right, that we didn't have any permits expiring because you slid them into an abandoned state as opposed to an expired state?
The only permits that went into expired status were the ones that people didn't pay for. Once they paid their fee, they were considered, that building right was locked into that property. So there's got to be a point where somebody's locked in, and because we had no other code section, once you paid for the permit, it's locked in. You may have to pay more fees to pull it out of abandoned and meet whatever the new provisions are, but the permit was locked in once you paid for it. Village had your money, and we may be getting more of your money, but we had your money, which was different than if you let it go and you never picked it up. So that was the distinction.
Okay, and so these that we're talking about have been picked up, correct? Okay. So do you guys, you're the new girl on the block, see the abandoned status section out there, or is Ty says we've been using it?
I don't know what you mean by abandoned section.
Well, instead of it going as an expired permit, it's
Look them all up on City View if you want and tell you what they're. I mean, but they're pulled by.
Do you understand what I'm saying, John?
Yeah, I'm not sure where in the code that would be, that if you have an expired permit, because it is an expired permit, that under the that if you don't do something in a certain amount of time, it expires. I don't know where in the code we would have that an expired permit becomes an abandoned permit. I'm at a loss.
So we probably don't have that in writing. That was a policy that was just being done because we didn't have a mechanism for it.
Yeah, I mean, I'm happy to look, but I'm not aware of an expired permit and our code being deemed an abandoned one.
Well, the fact that people have paid for these permits is what we were talking about. It's theirs. And yet at the same time, if they're just going to hang out there and not ever happen,
Well,
that's not fair either.
I think there's a distinction between the BPAS allocation and the building permit. So what I understood Mr. Harris to say is that what they were told is that once you have a BPAS allocation, that is your right to build. Now, if you allow your building permit to expire, what you may be able to build can change given the code. Setbacks change, height restrictions change, parking requirements change, and so forth, but you can submit and pay additional fees and reapply for a building permit, but you've locked in your allocation. So I think when we talk, we need to be cognizant of the distinction between allocation and permit.
That's what I understand. I'm more concerned with the fact that John can't find something that specifically references that. And I don't want to leave us out there hanging. And to be honest, I'm of the opinion this probably needs to be come back with some sections of the code to make sure we're not creating a problem instead of solving one.
Well, and I agree, but I think it needs to be fast because to solve a problem on a forward-going basis, which we can, you know, as Deb said, it's one thing to talk about the 5, let's set them aside, let's talk about the future. That needs to be fast to capture the people who it may be impacting.
A question. Jennifer, can I ask a question?
Sure.
Okay, we have these 5 we're talking about right now. Okay.
I looked all 5 of those up just now. They're all listed as expired, not abandoned.
Okay, but are there any, or do we have any procedure in place with the others that are sitting out there that are coming due, that would theoretically be expiring soon? Is there something, there's a trigger that you were aware of that you noticed?
There may be, I'm not aware of, but I don't work with building permits specifically, and Sheila's not available this evening, so I can find that out tomorrow.
Because in a form of CYA, if we're going to go down this superhighway, this ain't a path, we need to have some mechanism that advises people that you're going to be in expired status and what the, oh, shut up, I'm tired of spam calls. And what happens, what your options are, and that they will be changing.
So you said a few minutes ago that somebody texted you, wrote you, while we were sitting here, saying that a letter goes out at 30 days, and in the day that it actually expires, you get a second letter mailed out to you, that your permit is expiring, which is a good thing if we need to be following that. The question is once it's expired and they did not act on it, and I really think we need to classify these 5 a different way. But going forward, if they did not act upon it, the fact that it was expiring, and they paid for it, there's a distinction between the paying and not paying, then what happens? Do we have this abandoned status? Can we have this abandoned?
We have abandoned status in our system, and what that means is when you're in plan review and under revision, if you don't provide the revisions after a certain amount of time, the plan set, the review goes into abandoned status. That's when a property or a permit or a project is in abandoned status.
So it's an incomplete project.
Mm-hmm.
Okay.
That's the only time I've known since I've been here an abandoned status. And if Mr. Harris had, when he was planning director, if he did a director's interpretation memo, I'll be happy to go look for it regarding how they handled them. You know, I don't know of such one, but if he did one, I'm happy to go look for it.
You didn't do one, did you? No.
I just got one with Cheryl Shapari and Roger.
If you got to be on the mic, you know this. Sorry.
I can't hear him.
The book of director's opinions doesn't cover this. That was one of the first things I checked, but it was consistent with what we'd been doing before I was there. And in fact, I think there's even a letter that goes back to 2012 from James White that dealt with a similar issue with building rights not expiring, even though the code said they may expire. This is a very interesting area, but we tried to be consistent and fair. And if you paid your money, you had your building right. And if you didn't pay your money, you didn't have your building right. Now, as Ms. Raffanello was pointing out, look, things could change. The setbacks could change, the building height could change, the building code change, and you would be subject to all of that. But the essential right was locked in once you paid for it. And that's how we've been doing it since at least 2017, which was before I was here.
Tony, any comment? Oh, you're right. I'm sorry. I didn't finish public comment. Sorry.
Public comment with Van.
Van.
Van Cadenhead, Alamorada. If any one of you were to expire, you would be dead. It would be over. When they bought that permit, they had a certain amount of time to act on that permit. That's what their money bought them. If they did not choose to do that, and they received 30 days prior from the village a notice that their permit was expiring, and then on the day that it expired, it was expiring, I don't think they have any recourse. I don't see why you're even discussing this. I mean, they lost their money. If you snooze, you lose. I'm sorry. It's just, it makes no sense to me what this whole conversation's about. Because if you don't do what you say you're going to do with that permit, and you allow the permit to expire, you don't apply for a refund, you don't say you want to pull a permit, and certainly not treat it as a TDR and be able to sell it, because it's expired, it's dead. You don't do anything after you're expired. So, to my way of thinking, they're out of luck. And you should know everybody that gets a permit under those conditions that doesn't follow through to try to amend their status before it expires, snooze, you lose.
Any other public comment?
No.
Nobody
one
on Zoom?
No.
Okay. Okay, now. Did you want to comment?
This is an issue that I had a question mark on, and that is, I still have a question mark. I mean, that's like, I understand both sides of this pretty clearly now. And I appreciate what Ty has said. If that's the way we've acted in the past, obviously we have some history and a precedent that was set. That doesn't mean that we can't put a provision in place as we move forward. I certainly think that is a probability and a necessary addition to this. What to do about those that are still out there that may or may not have been told about that status, I'm not sure. I know that didn't say a whole lot, but
No, you did. Yes?
I have a comment. It seems to me that we have two issues here. One is the permit that expires, and the second one is a building allocation that you purchase. If we separate those two things, does that make a difference? Because, the former director said that once you purchase this, you own the building allocation. What we're talking about is a building permit for that allocation. So it is two entities that we're talking about here. Mm-hmm. You may continue to own the allocation to build on that property, but you may have to come back and reapply. It would be a simple process that the building permit expires, you continue to own that allocation as long as you're alive or you're passed on.
So, no, that's what my understanding is as well. But if not, what this says is if the permit expires, the allocation goes back into the system under administrative relief.
That may not be right.
That's the only thing that I think. They're two separate things, exactly.
Yeah, if you separate them, it makes it much easier.
I think if we set forth a relatively simple change in the code to say, as of X date, whenever the date it passes, moving forward, those who have not yet been issued building permits, and now you'll see a flood of people trying to get them before the code goes into effect, but it will go back. And so it's crystal clear what's going on forward. And then follow what other municipalities do with respect to vested rights. Have a date certain, and I think this goes to what Cheryl was saying, have a date certain by which any of those applicants who are in expired or abandoned status can submit their documentation as to their justification for vested rights, determination, and the basis for why they are claiming it. And those can be evaluated, and it can be either, I don't know if it would come to us or go to council directly, but municipalities do that all the time, or have it be a staff decision to say, you've got X time to come up and give us your documentation as to why you keep your BPAS allocation, even though your building permit is expired.
And we did that years ago with not related to expired building permits from BPAS, but we had a vested right. So I know exactly what you're talking about, Susan. And we could always put something like that in this provision to make clear so it only applies to this provision, because we don't want to reinstate other people coming with different types of vested rights. So
just with respect to the expired building permits, and you can readily identify the people it impacts. I don't have any problem with you notifying them at all. In fact, I think you should. And you say you've got until X date to submit your request to have this BPAS allocation maintained, along with your documentation that supports the fact that you have changed in reliance, like all the things it takes to actually get a vested right, that you have done something in your life that you changed in reliance upon this BPAS allocation. You have to have done something to change. It doesn't need to be shovel in the ground, but you need to have some justification for not having acted upon it, and then it can be determined under the criteria of normal vested rights.
I think I agree with you 100%. I think that one thing we can accomplish tonight is modify this modification down here by creating a date certain for any issuance of allocations as of February 1st shall expire upon choose a day. And such will return to whatever we've got written down in here as the allocation system, subject to possible modification due to extenuating circumstances, family death, hurricane. There are things that happen. Your land caves in because you had a hurricane, those type of things. But I think we can accomplish that tonight by stopping it from here forward. Today's January 8th, national title tonight.
It would be as it passed village council, but we can put that line in that provides a date.
March 1st. I personally would like January 15th, but that's not going to happen, so. But I think we can accomplish that tonight and then address this
pool of five.
The pool of five said whatever else is sitting out there that we're unaware of. Would that work to do this?
You look like you're going to say something.
No, my only question is, so we have the allocation, we get the permit expires, now it's an allocation without a permit. So now, don't they have those 180 days to go pick up a permit again?
No, the allocation would go away under this language.
Under this language?
Yeah, the point of the amendment is to tie the allocation with the permit status.
Mm-hmm. Okay, so can't we just say, okay, now we're back to this situation where we have an allocation without a permit? Why do we build up this pyramid and then the whole thing collapses after this permit expires? I feel like we should, okay, now we're back to this allocation without a permit.
But then you never have certainty in the village. You're creating commodities that don't otherwise exist right now for profit with people that don't have any intention of building a single family home, even though that's what they said at the BPAS allocation. So I think there needs to be notification, as Cheryl and Tony and Deb have indicated. But there needs to be, you received a BPAS based upon an application of some kind to include, at least generally, what is going to be where in the village, and you need to do something about that, or you may lose your BPAS allocation. And if they want to do anything else, they can follow the appropriate mechanism within the time frame that they have to do so with the village. But if it expires, then it expires, and the whole kit and caboodle expires.
Okay. The only other question I guess I have would be, of those 5 properties, are we seeing, is there partial construction on any of them? Or are they all?
There's no construction on any of them.
Okay.
Doesn't that enter a whole new world when you've been doing partial building?
I don't want to strip them of a building permit.
No, I'm just
for
saying,
a house.
but if they haven't done, if you haven't done anything,
Yeah, no, I get it, yeah.
So it sounds like we're all in agreement, or most of us are in agreement, I'm making an assumption here, that this is okay, but it's got to be from date certain forward.
I'm even okay with the walk back, to be honest. I think, the whole collapse, if they have that expiration, the language we've talked about, they can always extend and things like that, that's there for them, right?
the extending your permit, yes, that's
Yeah.
already there.
Okay.
Extenuating circumstances occur. But you
So-
still have to act on it.
Yeah, okay.
So you would like to see it retroactive, in other words?
No, not retroactive. I don't think that's fair.
Well, on the 5,
No, what I said
Apply
is
to the
that I
5.
think that this does exactly what Susan said, and she said exactly what she was supposed to. It ties them together, and then I understand that, the walk back, creates that commodity thought, and that, I don't,
oh, I misunderstood.
yeah, no.
Because we got 5 people out there that are already under the assumption that they can reactivate their permits. It's
Yeah,
but I'm sure in all likelihood, maybe 3 out of the 5, but
Right, which is why I suggested a vested rights look-back period and have them come forward.
they just need to justify what they've done, what they haven't done.
But we can,
So do we want to recommend that this is slightly modified? Is that what we're doing?
Has anyone in the group, are we able to wrap around enough to be able to make a motion that would allow us to move forward? Or do we need to?
Try this.
No, I think so.
Let me try it. I move that we amend the motion as presented in section,
Cheryl, you want to speak closer to the mic?
okay, I move that we amend the motion as presented in section H of the proposed allocation application procedures. It reads, upon expiration of any permit obtained as a result of an allocation, so forth and so forth. This section shall become effective on March 1st, 2024, whatever date the village council finds appropriate upon acceptance.
Okay, so we want to put a date certain in,
I'm gonna
is what
put the
you're saying.
concept
But I don't think we can put the date in.
I don't either, but I think it needs to be phrased as such.
Right. John, is that how it should happen?
How do you want to
It's
phrase the
just
date?
Yeah, I mean,
blank in there?
yeah, that's good, and I think the date we can discuss, will really kind of be dependent on when second reading is, when it passes, and that, I think, will be the date we can put in.
Do I need to add, upon expiration of any person issued, why don't I phrase this, upon expiration of any permit obtained after said date, and I would leave that blank, and
Yeah.
then date to be determined upon acceptance. However, I want to make sure I haven't left anything out.
And then there
can
was
I
also.
piggyback and continue on that? What Cheryl said, along with a subsection that said, as for any building permits that have actually issued and been picked up, I don't know what the proper verbiage is, but issued prior to such date, any applicant who had received a BPAS allocation that has an expired building permit shall come, have an insert blank date to submit an application for determination of whether such allocation constitutes a vested right that flows with the property or that runs with the property.
That they can be renewed, or they are being renewed.
Yeah,
in
so
some way.
any permit that expired before that date would then be eligible, as I understand it, be eligible to go through a vested rights determination, which we actually have a process built in, and we could, I think, refer it back to the vested rights process specifically as it relates to this.
Right, so long as we capture then the middle ground, which is those who haven't expired but have already been picked up. So whether or not it's any building permit that issued prior to that date, I think they need to be part of the vested rights determination, many of whom will still have months and months left, but they need to be made aware that the way the verbiage is, it's
picked up after, but we have this subset of people like within the last 6 months that have picked up permits. I think they need to go through the vested rights determination process if they're going to take a contrary position to code as well, and justify that why they can't do it within 6 months.
How extensive is the vested rights procedure?
It's pretty extensive. I mean, it's set forth in sections 30-581 through 584, and it talks about how to. I mean, this was for something different, it applied generally, and it was limited until July 1st of 2002. So we could piggyback upon that, but it talks about. It's the quasi-judicial hearing that they go forward, the standard, the burden of proof, the standards for and criteria for vested rights. It goes through a number of different criteria that they need to do. One of them, as Ms. Raffanello pointed out, you had to actually do something.
All right, so they would have to go through a quasi-judicial process.
Yep.
Okay, so the people who were previously in this situation, with the exclusion of these current 5, didn't have to go to such extensive hoops. Correct?
Well,
So now we're going to make these, because really we only have about 5 people other than anybody that has currently picked up a active permit and so forth. But right now we got 5 that we know are hanging out there. So now we're going to ask them to go through an extenuating sense of processes in order to reactivate their permit.
I think what's
I think that I think that right. I kind of have a problem with that. I can see moving forward from a certain period of time having that be a requirement, but those that are currently under the old process should be able to be processed the way previous.
But again, the old
owners are
process is not in the code. I mean, that process that we're talking about is not in the code. So we keep saying the old process, and it could have been something at one time. It could have been another thing at another time. It's not something that's spelled out in the code. I think what I understand is being proposed is that this is an issue we want to deal with. We're recognizing that some people have expired permits. We want to give them the opportunity to, reinstate those or revitalize those through a vested rights determination. That's how I'm understanding it, is that that the proposal would create an exception for them and an additional ability to get something that they wouldn't otherwise be entitled to under the current provisions. Did I sum that up right?
I think so, and I think I saw Jennifer with her head in her hand. I think I can streamline what I suggested a little bit better.
Just because I'm very confused, there's like.
No, and I think.
And if I have to explain it at a council meeting, I want to know what I'm.
Right. So, and Cheryl, I apologize if I misstate what you said, but my understanding is that the motion that Cheryl made is that the language include an effective as of date. What I would suggest is for any permit that is not expired as of this date as opposed to issued, that takes care of the middle ground that I was concerned about. And then we go forward with for those that have already expired, vested rights determination.
Or proper notice,
With proper notice.
Yeah.
Mm-hmm.
Is this dead yet?
Did we simplify that enough to
I think
work?
So, yeah. I think I understand. And the date you were looking for in terms of the deadline for a vested rights determination was 6 months from like the expiration of either 6 months from the date of passage, or I guess 6 months from the expiration of any permit, because there could be ones that haven't expired yet and then would expire after the.
I would make it clean and just do the same date to pick up from when it passed second reading. If somebody gets an extra 3 months, they get an extra 3 months. I mean, but I think it's going to be, that'll be very few that I assume will expire between now and when the second reading happens, if
Well,
any.
yeah. I mean, we've only got 5 that we're actually dealing with over all these years, and so.
I would doubt another one comes in.
If we get one, we might.
They would come in and ask for an extension after the first reading.
I would.
Right,
I would
right.
hope.
And what we've done is we've made them aware of that they need to come in and ask for that extension, hopefully, if they're paying attention to us. Do you have enough information on this? Do we have enough that we can just vote yay or nay?
You would have, I just want to make sure that the motion is to, how Ms. Raffanello phrased it. Or
I will
however.
second what Ms. Raffanello. Does that make that easier?
Yes.
Okay,
Ms.
and-
Raffanello made the motion,
And does somebody have that motion so that it'll go in the minutes properly?
I wrote it down and
Okay.
we have the video too that we can.
Okay, all right. So you made the motion, right?
Yes.
I need a second.
Cheryl.
I seconded it.
I'm sorry, she seconded. So now we need a roll call.
Susan Raffaello,
Yes.
Cheryl Culberson,
Yes.
Patrick Foley,
Yes.
Tony Hammond,
Yes.
James Ryan,
Yes.
Lori Lalonde,
No.
and Deb Gillis.
Yes.
Motion passes 6-1.
All right. Next tab, tab C.
Tab C is an ordinance of Islamorada Village, Violence, Florida, considering the request of Ty Harris, PA agent for Sojourn South LLC to amend the village's future land use map from Conservation C to Mixed Use MU for the subject property located on Lower Matacumbe Key with real estate number 00394480-000108 as legally described herein, providing for the transmittal of this ordinance to the State Department of Commerce and providing for an effective date upon the approval of this ordinance by the State Department of Commerce.
Thank you. Did you want to handle these individually, or did you want to handle these together?
Let's handle them together, but of course we have to vote
individually.
individually.
Let me
So
just
you wanna
read
read the other title, please?
And I can do that for all of them, because
Yes.
there's a couple of them that have
Yes.
companions like this. The other one is tab D, which is an ordinance of Islamorada Village, Violence, Florida, considering the request of Ty Harris, PA agent for Sojourn South LLC to amend the official zoning map from Conservation C to Commercial Fishing CF for the subject property located on Lower Matacumbe Key with real estate number 00394480-000108 as legally described herein, providing for the transmittal of this ordinance to the State Department of Commerce and providing for an effective date upon the approval of this ordinance by the State Department of Commerce.
Thank you.
Okay.
Thank you. So as Mr. Quick has stated, this is for Sojourn South LLC requesting a FLUM amendment from conservation to mixed use and a zoning amendment from conservation to commercial fishing. This is a site that is located in Lower Matacumbe, adjacent to the existing Sojourn property site that was recently platted and approved for 6 single-family homes. The site has been historically used for commercial fishing purposes, for storage of lobster traps and repair of those traps and docking facilities and whatnot. The applicant is requesting these changes in order to bring the zoning back into the same zoning that it was in prior to the village incorporation, which at that time was commercial fishing, I believe that's what it was. The subject property is 1.74 acres. There is no significant habitat on the property. It's mostly devoid of all vegetation except at the shoreline. There is no state or federal listed animal species. It's not any recognized habitat, and it's not within the state's conservation recreation lands boundary or critical habitat area. And pursuant to the village's GIS data and records, the parcel is not defined as any specific habitat. In the subject area, the property, as I said, has a conservation FLUM designation. Adjacent properties to the south are designated mixed use with commercial fishing operations. To the north, the adjacent properties are designated residential high and are currently vacant and have been permitted for 6 single-family residences. The properties to the east across Overseas Highway are conservation, and to the west, the property directly abuts the cove, but across the cove, the properties are designated residential high with a mix of condominiums, duplexes, and single-family homes. The character of the subject property is vacant and the surrounding area is mixed use with a collective of fishing operations, multifamily dwellings, and single-family residences. And again, the existing zoning is conservation and the flood zone is AE 10. So there's an analysis in your packet of both the FLUM and the zoning change. I can go through that whole thing if you'd like. I can have Mr. Harris come up and make his presentation, whatever you prefer at this time.
I'm happy with Mr. Harris, if everybody else is. Okay. Good evening.
Ty Harris again for the record.
It's not on. The green button.
All right, got it.
Perfect.
All right. So, as Jennifer was pointing out, this property has always been commercial fishing. It's never not been commercial fishing. And I've heard several stories as to why, when the village incorporated, it was suddenly rezoned to conservation. The first story was that it was to protect the view corridor for the project across the street, and by making it conservation, they would have a nice view of the Atlantic Ocean. The other plausible story that I've heard, amongst others, is that the village was actually considering purchasing it, so they thought by changing the zoning in the flume to conservation, that would actually lower the price. So here we are 20-something years later. The property is still being used as it was in the 60s, which is for commercial fishing. The village has never attempted to purchase the property. I haven't heard anything more about Captain's Cove trying to protect a view corridor to the ocean, which obviously they wouldn't be entitled to, only to the water in front of them. But it doesn't make a lot of sense to keep it in conservation when there's actually no conservation land there. In fact, it actually hurts the credibility of the village in the comprehensive plan when we slap a zoning on something that's not consistent with the characteristics of the property. If we're to use conservation, let's use it right to protect conservation land, not to take property that's scarified and try to protect it so we want to buy it cheaper or whatever the other alternatives would have been. So there are no plans to develop the property. The only thing that we've discussed is actually hardening the shoreline with riprap and putting in a seawall or a dock system, because we can't do that under conservation. And if you've ever been down to the property, you will see that there are what we call hurricane holes. Everybody know what a hurricane hole is, right? It's when the commercial fishing boats back their motors in and blast a hole into the existing shoreline and then come back in and park or anchor up so that they're protected from a hurricane. All they do is degrade the shoreline, cause more non-source pollution going into the water, and create a giant headache for the property owner, because if you make the holes big enough, you now need a DEP, an Army Corps, and a village permit to fix them, because you can't just go back and put the dirt back in. So the only thing that we've discussed right now is coming back in with a seawall and some probably riprap, and then coming in with a dock. But there are no plans to develop the property. The nice thing about commercial fishing is that what's happening on the property right now is the only thing that can happen on the property without a minor conditional use. Every other use that you could possibly contemplate in commercial fishing requires a minor conditional use. And the only thing that looks kind of interesting in that list of categories is there are opportunities for deed-restricted affordable housing. So maybe that's something in the future, because as we all know, there's not going to be anybody here to prepare your meals or clean your clothes at any of the resorts, because we don't have any deed-restricted affordable housing, and we just keep losing more of it.
Waterfront, it can't be used for affordable housing.
It can in commercial fishing.
Sorry, I forgot about that.
Yep, that's why it's kind of a unique zoning, because it's dedicated to commercial fishing if you look at the approved uses, but it also has this little section in there for deed restricted affordable, which I would presume would be to support the fishing community that would be working there. But that's for down the road, if at all. Right now, it's just to keep the use going and to not make it a non-conforming use. There's no reason to have it as a non-conforming use. There's been a lot of discussion in this last year over non-conforming uses, legal or otherwise, and my clients pay attention to that, And I think that was probably the main factor about reestablishing the zoning that had been on the property, was to not get into an argument about non-conforming uses and legal non-conforming uses. So if you have any questions, I'm ready to answer them.
Why mixed use? Why mixed use?
That's the,
On your mic.
Oh, sorry, why mixed use?
because that was the flume category that lined up for commercial fishing.
The only reason half of that area still exists is because there were mangroves. When I lived down there 40 years ago, there were mangroves on a healthy portion of the shoreline. Now, they've had a little help in disappearing that involved more than just the boats.
Well, I can tell you my clients are interested in preserving the mangroves because the mangroves protect the shoreline. And that basin is wide enough that there would be no incentive. You know, on a man-made water body, you're allowed under DEP rules to take out every mangrove. You're not required to protect any of them. But that makes no sense, because if you're trying to protect the shoreline and you have that kind of width in the basin, you would want to do a dock system that incorporated the mangroves into the docking system. We've seen those. It's harder to do on tight canals, but this is a boat basin that has no issues with how far out you could go.
The only reason anything still exists down there, having been down there through 3 hurricanes, is because the mangroves protected, and when the ocean came screaming up over US 1, the mangroves were what held onto the land. Jimmy, weren't y'all living there for the last one?
Yes.
Okay. It just, yeah, went down there too many times. I don't have I just wanted to know what mixed use was, the intent was, but I want the mangroves to stay.
That's not,
I don't care if we have to put something on this, but those mangroves need to stay on that shoreline, and that whole shoreline needs to be mangrove.
we can't condition a flume or rezoning, but I can tell you that that is the plan. And any dock plan that we propose to the village will protect the shoreline. It just makes sense. It's smart if you're trying to stabilize it, to keep the mangroves. There's no reason not to have that.
Was there 1.74 acres?
Yeah.
Yes, ma'am.
Well, all mangrove communities are protected by the state anyway.
Well, so here's the interesting thing. If you have a man-made water body, which is what is right there at Captain's Cove, they're not protected. If anybody that's on a man-made canal has the right to take out every mangrove and pay mitigation fees. The smart ones keep their mangroves. The ones that aren't so smart tend to rip them out. But you'll see different varying dock systems on these canals where one will be 2 feet further out or 3 feet further out than the other, and those are the ones that are designed to protect the mangroves, which is the smarter way of doing it. But there's no requirement in state law anymore on man-made water bodies. On natural water bodies, they're absolutely protected, but not on man-made water bodies.
I have a question. I understand why you picked mixed use, because it goes with your commercial fishing zoning. And I agree with the commercial fishing zoning because of the restrictions that it doesn't allow you to do. But in the mixed use, it also allows you to increase the potential of the market rate values, or the market rate. Our report says it increases either 10 market rate residential dwelling units, could increase, or 26 deed restricted ones.
So again, under the commercial fishing approved uses that you can do as of right, what's occurring on the property now is exactly what you're allowed to do. Any other of these uses, which are hypothetical, and I have not been informed of any plans or discussions about doing that, would require a minor conditional use. So it's not as of right. So you're going through the public hearing process if you want to do something different than what's going on there now.
And we know people that won't do that, and we know people that will do that.
Well,
just a point.
My point is that my clients have owned it for 20 years, and it's been commercial fishing, and they've leased it out to
and next
Lobster
month
Walk.
they may sell it.
Yeah, I mean, I can't tell.
You can't tell that.
No, nobody
I'm
can.
not asking you to tell.
Nobody can. I can just tell you why we're asking for it and why it makes sense.
So if we do a zoning flum change to mixed use, and then approve the commercial fishing zoning district. The next step would be to change the zoning district so that you could build 10 market rates if they'd fit, and you can meet all the other setbacks.
They're not really going to fit. Majority of that parcel is
I'm just going by what's,
bay bottom, it's water.
so we build one or two, but we've upped the amount of allocations that we need. We're increasing the amount of allocations.
I mean, if you look at the comp plan and the discussions we've had over the last couple of years, protect commercial fishing, protect commercial fishing. So here I am trying to protect commercial fishing, and this is the first application you've had in a long time where somebody's actually asking for commercial fishing, and now we're going to worry about what could happen being commercial fishing under minor conditional use, when I'm not asking for any of that. All I'm asking is for what's there now and the ability to put in and stabilize the shoreline and put a dock in.
I think what she's really referring to is that the parcels to the south are also CF.
Yeah, they're commercial
right?
fishing.
They're commercial fishing, zoning commercial versus mixed use and commercial fishing flum.
Right.
So I think that what she's really saying is that had you come to us and said, hey, we're going to do this commercial fishing zoning and commercial fishing flum, it would have been a slam dunk. So she's trying to inquire as to what the purpose is in the reasoning in asking for mixed use versus commercial fishing.
Again, looking for a flume that allows you to do commercial fishing. If you were to come back and want to rezone the property, you would be back here in front of council and dealing with all the lower mat people that would come out and with their hair on fire and go after you.
I get the commercial fishing comes under the mixed use, but if there's no idea to develop or sell, or I'm not sure, I don't want to assume either, what's the idea of if you have it legally or legal non-conforming, why mess with it if it's doing what you say is going to be happening there?
It's just I'm the one who picked it. Gotcha. So my client said, make sure we're good with commercial fishing. And so I always go with mixed use because that in the future is a better classification. If you want to borrow money on the property, you're going to you go to the bank. You're going to have it better with a flume of mixed use than you would with commercial fishing.
Mm-hmm. What was it when it was under the county?
Commercial fishing.
It was just commercial fishing?
It was called Commercial Fishing 18,
so,
Zone 18.
So why don't we have a designation for that in our code?
We just have commercial fishing in our code. The county actually had zones of commercial fishing, which was a different concept.
Just historically, I've been here since 1960. I can't recall that piece of property ever being used for anything other than what it's being used for now. So the fact is, it's going to remain and be used that way.
Right.
They're either going to be in violation of code, or we're going to go ahead and say, yes, let's figure out how to make this
I have
permissible.
no objection to legalizing
Right.
what they're doing. I really don't. I'm just making sure that we're not setting it up. Not your client, but your client could do anything tomorrow.
Well, that was my question, and that's where I'm trying to go with this,
Okay.
is can we get a designation that says for commercial fishing use? In other words, is that a reasonable request in our code, or do we already have it in our code, and therefore can designate that area?
I would argue that you already have it in your code because the only use as of right now, is what they're already doing there, which is commercial fishing. Anything else, even allowed under commercial fishing, requires a minor conditional use. And there's not even a provision in commercial fishing that allows you to ask for a major conditional use. It's just a minor conditional use.
Yes,
So I'm taking care of it as best I can because I'm asking for the closest thing that it was in the county, which is commercial fishing 18, and that's what we have.
And that's when you look at the map, that's what the other parcels to the south are, is mixed use.
They are mixed use. We just
I just looked it up. I'll
Yep.
show it to you if you want to see it.
Right.
The Habitat survey says it's 2.85 acres. Is it 1.75 or is it 2.85? And why the difference?
It would be the bay bottom and the upland.
So the upland is 1.75. And then my understanding is that this property actually went to litigation when the village was incorporated due to the zoning and the flume of conservation. And the conservation was upheld. Now, right, wrong, and different, whatever the reasoning may be, we did incorporate Islamorada as a village to not have the fallback justification. Well, this is what it was from the county. If we wanted to be the county, we wouldn't have incorporated. And all of the processes were gone through already legally on this property to confirm that conservation was an appropriate designation.
It
And
wasn't
to-
the appropriate destination by the characteristics of the property. It was deemed appropriate because nobody challenged it in time. A little different.
But they had the opportunity to challenge it in time, and they're deemed now, I'm not saying yes, no, or indifferent, but my issue is we see this all the time. Well, the county used to be it this way. Personally, I don't care. That's why we incorporated. It's a different question than whether it's an appropriate use for the village now.
And I understand that. But if we were to read what the conservation category is for, I challenge you to check off any of those boxes that would actually apply to this property. So what you're doing is you're actually undermining your conservation zoning district because it may be perceived as a sword to achieve goals that can't be achieved otherwise, such as purchasing the property if you really wanted to buy it. The village sat 25 years and didn't buy the property. So if you made it conservation because you were going to buy it cheap, you didn't buy it. If you made it conservation so that there was an unobstructed view corridor from Captain's Cove to the ocean, neither one of those are legitimate planning reasons
Those
for
also
doing
aren't
it.
in the minutes of when, or the reasoning and the justification for the change at all. So again, anecdotal, just as the reasoning is. So what we now have is whether we're going to upzone a property, which we're not supposed to do at all under our own codes. We're not supposed to upzone unless there is an actual need for it. And we have, yes, we have, and the need justification in a lot of these applications, this one at least had some in it. There was 11 commercial fishing, one of which is vacant. So we have 9% underutilized, and we have an application that says numerous times, and an analysis of the applicant as well as staff based upon the representation of, we're not going to change anything. So we already have a legal use. The application doesn't say anything about a seawall and a dock. That is, we're hearing for the first time tonight. So the application in front of us is, we don't want to change anything, we just want it just in case. And that always concerns me because you already have a legal non-conforming use. It's already legal what you're already doing.
So you would equate a legal non-conforming use with the same rights as somebody that actually has a legal use under the zoning classification?
Nope, that's my point.
That's my point too.
Okay.
And as you were aware, there was a very interesting case that came out this summer from the city of Marathon about what you do when you try to do things with making things conservation and give them uses that aren't real uses. That's the city of Marathon versus Shands, which didn't go so well for the city of Marathon. You should probably look at that case. It will send chills up your spine. And Shands being Dr. Shands Hospital in Gainesville, probably not the right family to tangle with if you're the city of Marathon. But the third DCA ruled on that case and basically said that beekeeping and camping aren't real uses. So guess what the uses are in the conservation district in Islamorada?
But yet if we change it, but without the change, he wouldn't have the challenge. If we change it in the future, he has the challenge. Right now, the challenge was had 20 years ago. And for whatever the reason, expired statute of limitations, didn't do it in the timely fashion, the judge actually, he's already had the opportunity to challenge it once legally. So now we're opening up on an application that says they don't want anything to change, that we're opening it up for additional challenges in the future, and we're giving the landowner rights that landowner or a subsequent landowner would have under mixed use, making it easier to change the zoning, even if it was initially zoned highway commercial tonight. You don't have to go through 2 steps. That is the precedential concern.
I think, look, I've got the application. I have a staff recommendation of approval. I don't want to, I think John can probably give you a taste of what the Shands versus City of Marathon case is about when you take conservation and put it on a property to keep something from happening to the property.
But we're not putting it on the property.
Well,
it exists, and it's already
guess
had
what?
the
It
opportunity
existed,
to be challenged.
It existed on that property as well, and it was well beyond the year, 2 years, 3 years. It had been on there for a while. But look, I've already given the data analysis to show that commercial fishing is needed in the village of Islamorada. That's in the file.
Well, the data analysis, and I'll say this now because I'll have it again for the next 2, is based upon a study done for unincorporated Monroe County, not Islamorada, for trends based from 2000 to 2010 and was 2011. And even in the application and the staff analysis, we're looking at school projections only through 2015. Those aren't projections, those are 8 years ago. And the population, looking at trends from 2000 to 2010 at the tail end of the greatest economic collapse of that real estate saw, to include the Keys, I don't think is an appropriate data point upon which to rely.
Again, you use what's out there as a planner, and that's the data analysis that's out there as a planner. And we already know that we also have a section in our comp plan that talks about protecting the essential, essence of the village with the fishing capital of the world, commercial fishing. Again, if you don't want to recommend approval of it, that's okay.
So here's my take. This I like, the zoning, the commercial zoning I like. What I don't like is the mixed use because it's an up zone. Okay, so, but wait, give me a minute. I understand it is the only flume that we have available
commercial fish.
For that.
Right.
But that still doesn't mean that maybe we need to get more creative like we're seeing and say, okay, that's the flume we need to use, but there's a limitation on it. And I know that we can't do that.
Right. I mean, I'm going with what the categories are available to me.
I understand that. I'm telling you what I have a problem with is it's the upzoning and the potential. I don't say it will even happen, but the potential is there, and we are looking like we're upzoning something.
I don't think you're upzoning because the use of the property hasn't changed.
No, I know
but
that.
Every few years, there's a new code officer that goes out and red tags them for operating a commercial fishing business on a conservation property. So,
Can I ask a question, a second one, since I've just reread? I'm sorry. Why not commercial fishing?
That's what I was asking.
Yeah, why not commercial fishing zoning?
there's the only flume that I'm aware of that allows for commercial fishing is mixed use.
That's correct.
We just found it.
That's correct. Commercial fishing falls under the flume.
Yeah, it follows it's 30-694.
That's exactly what I was asking.
Yeah, that's because it seems to me the way
that's the zoning.
Admittedly, this is not my area of expertise, but I'm just telling you, we've always known it was grandfathered in as commercial fishing.
Right. If you look at commercial fishing on our map, I think all the properties in Islamorada have an underlying flume of mixed use, and then they have a zoning of commercial fishing. So we're consistent with what everybody else is doing.
That's correct.
Yes.
Right.
So is there a way to tag that on so that let me back up. First of all, you know that I'm on the environmental side about 99% of the time, and so, but I also know this piece of property, and I know that the commercial fishing is an integral part of our community. It is part of the community character. if we hadn't had this lengthy discussion, my motion would have been to approve as it is. But hearing this, I think we need to have a mixed use / commercial fishing only provision that guarantees the fact that what you just said, Ty, it's been that way for, let's say it's been that way for 40 years or 50 years. We want to see it that way 40 years or 50 years down the road. We don't want to see a condominium pop up there or affordable housing units pop up there. I don't care what it is. We want it to be a commercial fishing site. Is that the general consensus?
That's mine.
That's why I was so confused, because the way I read the flume, and I admit I may have read it wrong because I was scanning, but I thought that was where we could go.
You were
So I read
panicking
it
me for a
wrong?
minute. I was like,
Part of
I'm
the
pretty
mixed
sure
use?
it's mixed use is the flume and commercial fishing, and mixed use is the only flume category that commercial fishing falls in.
Because I,
No, I understand that,
Yeah.
but I would like to see some kind of special district, or is what we've been calling them lately.
we all agree that this is what it should stay, and however we get here is how we do it.
But we don't,
Whatever we title it, but it needs to, I'm sorry?
you just need to sit close.
I just need to make sure it stays commercial fishing and working waterfront.
The only thing I can say, and I've said it before, is that if you were to go outside what's happening on the property right now, you would have to do it through at least a minor conditional use approval. And those things that are outside of what commercial fishing allows is what affordable housing.
I'm looking at it.
I mean, there's a few things, but where are you going to get, if it even allowed residential, where are the entitlements coming from? Because we
But
don't have any.
that's not the argument. The argument isn't where the entitlement's coming from. The argument isn't, will your client do this? The argument is, it could be done. Not that we want the commercial zoning, but I say I don't like the line that it will increase the market rate up to 10%, 10 units.
So if I could,
Yes, please.
I believe that if the LPA wanted to, they could recommend that you create a sub-area under mixed use for this property and limit the developability potential of the property to commercial fishing or whatever. We have several sub-areas under, in our comp plan under objective 1-2.11. We're actually going to hear about one later on this evening. So I think, that might be an option if the LPA is interested in that.
I think that's the phrase I was trying to reach for, is the what are you calling it?
Sub-area.
Sub-area. So that it is, they can continue to do what they're doing, they can do it legally, they can have that, but that's all that they can do going forward.
So, I apologize.
Go ahead. No.
So this, you keep referencing that, you have to be doing what the continued use is. That, I see, only applies to kind of one section, though. Is there a way that could apply to the other sections? Do you know what I'm saying, Jennifer? So right now, that applies to the commercial, retail, low and medium intensity uses. It doesn't apply for he can go for a minor conditional use for a single-family dwelling unit, and that could be approved, and he can get rid of the commercial fishing.
Correct.
Yeah, so it only applies as if he's doing a commercial minor conditional use that he can't get
What
rid
only
of.
applies?
He can't get rid of, or you can't reduce the space of the lobster trap construction. Is that my understanding? I mean, could that language apply to those other
So
things?
what I'm suggesting is that if the LPA wanted to recommend to establish a sub-area policy under the mixed use for this particular site and do sort of a site-specific zoning, you could limit him in any way. Like, you could say he can only do commercial fishing, or he can only have one house, or whatever the case may be.
What's your thoughts?
I mean, we want to use it for commercial fishing, but I don't know, are we going to spend a year putting a sub-area policy together? I mean,
Not if you write quick.
Right, but, commercial fishing
But
could
if
also
that,
be
is the
having-
onus now on me, or is the onus now on staff to do that? Because I've paid my $8,000 to be here tonight. My client has.
We don't have a problem writing it out. I
Well-
just want to make sure that we meet all the little
It's the
sections.
applicant. It's a choice. It's your choice, because if we do what I think we're talking, we could say, well, no, we're going to deny it this way, but we'd approve it that way. And it's your choice of what you want to do going forward.
Well, let's put it this way. What I'm thinking about is, commercial fishing also means a section of, would we be okay with there being a location or a facility for the sales of commercial fish, of the fish?
Sure.
Right? And that would need, could you build a structure in the commercial fishing zoning, FLUM? Or would it have to be mixed use?
Whatever the board's
use.
desire is, I'm going forward next month.
Okay.
And they'll up or down it, and we'll deal with it then.
Let me make a suggestion, having just rumored through this. My eye is not twitching yet.
Zoning.
I could motion to approve a recommendation to council that a creation of a sub-area for commercial fishing be imposed and placed on the lot in lieu of the current zoning?
In addition to.
In addition to the current zoning, that would allow commercial fishing and related activities to continue as they currently exist. Does that sound reasonable? Does that meet where we're going with this? I want to make sure you get what you need to operate that property.
We were getting what we were doing with the as-of-right uses under commercial fishing was covering exactly what's going on.
Okay.
And that's what I was comfortable with. I mean, it will never stop, and we will always be, whether it's the LPA now, the LPA in 20 years, the LPA in 30 years, we will always what if, because we think 3 moves down the road, because we've all seen things happen that were not intended. So we go, okay, how do we stop that? But that's where you start causing a whole nother set of problems, because if you're now saying, well, we don't trust the village council 5 years down the road or 6 years down the road to do the right thing, because we have an ordinance right now that says this is what you can do. And we got to trust the ordinance, and we got to trust the elected people that we hire, that we don't pay them very much money, but every 2 years we get another group in, and there are standards that have to be met. So whatever your pleasure is, but what the request is consistent with the use of the property. It's the historical use of the property. Use of the property has never changed. Actually, the property came into existence from the dredging of that basin. That property became that property because somebody dredged the Captain's Cove Basin and created that property. So that's how it came about.
Cheryl, so did you actually make a motion? Or was
I
that
moved
just
whatever it was
a
I just said.
discussion?
Okay,
So if I would like to go down that thought, I don't know how, do you have another comment before we?
I do see. that
Actually, we haven't had public comment yet, so we can't.
We can open up to public, I don't mind.
You got more you want to say before that?
I just see that it's been used as commercial fishing ever since I've ever known that property. So, I mean.
I don't want to deny that.
Yeah,
and
it's hard to deny that.
My other
wanna
concern
deny
is
that.
if we start tailoring sub-areas to individual parcels, there's a whole thing about you can't do contract zoning, and you start checkerboarding this. Well, we're worried about what this parcel could be, so we're going to do a sub-area. Sub-area implies more than one piece of property.
Yeah.
That's my other concern. So are you going to do a sub-area where you wrap in Lobster Walk next to it? I mean,
Sure. I'd be happy to do that.
you probably need to talk to them about it.
Well, that's true.
let me make a suggestion, though, because do we have to use the word sub-area, or how about if we say we correct the area it was designated to commercial fishing?
I think so.
Because it was always commercial fishing.
I think you need to use the sub-area.
Sub-area?
For the comp plan issue. For the zoning, it can be commercial fishing for,
Okay.
The zoning is fine. I don't have a problem with the zoning.
it's the
It's
flume.
it's the flume that I'm having the problem with, and I think the sub-area solves that problem for me.
But the flume is consistent with what is adjacent to it in the next few properties. So we're not trying to, he's not coming to us and it's like, oh, we're going to do commercial fishing, but we want the flume to be, something else. He's very consistent. And there's a process that's going to take place that if the applicant moves forward and wants to do something else, there is a process that they have to.
A public hearing process.
Right. And then so we can address those situations as they come about. But but he's not asking for something that is highly unreasonable. He's asking for something that is consistent with what is adjacent to this property on one side, on the southern side, as a matter of fact, and for what the intent is.
He's not going to be restricted by the mixed use. He's going to be restricted by
Zoning.
the
The
commercial.
commercial fishing, that's what he's going to be restricted
The
by.
reason for the mixed use, why he's applying for that is under the code, under commercial fishing, that is what pushes you into the mixed use flume category.
So back to taking this into two
Right, there
parts.
wasn't a more restrictive flume for me to ask for. That was the only flume.
All right,
It's
so-
like, you're a size 8, you're a size 8, you're a size 8. There's no size 12s around here.
Okay, so we're going to take all of size 26, reduce it down. Under the flume, we have to go mixed use, but then we further restrict it with the zoning, am I correct?
Right.
Okay, so that's the sub area. So now we have to split this back out where previously we combined them as for conversation or discussion points, correct?
No, I think you just said something.
Well, yeah, I just want to be clear, the sub-area is part of the flume and the
part of
comp
the
plan,
flume.
not
Okay.
the zoning.
And it is. and
Let me
we need to-
correct my notes, they're all over the place.
We have to keep in mind that it is absolutely erroneously designated conservation. It was not, never was, never has been conservation. That is a wrong designation. There's no way in this world
I'm not sure.
that was correct.
Denying that.
What's that?
I don't think any of us.
I don't think any of us are denying that.
No.
We're not denying that it was.
But it's there, and I'm trying to
It's
correct the
zoned.
problem that
Yeah.
It's been conservation, but it's been used for commercial fishing, which has, in my opinion, just as an important, position in our community.
And the only thing, just so you guys understand, the only thing I'm trying to weigh here, is it better to leave it as a legal non-conforming or correct the issue? I don't know if you guys have more experience with something that came in front of.
Have you seen the last
I
few?
think
I don't want to set a precedent. I don't want to set a precedent that, hey, look,
correcting something is better than
then I think our answer is pretty simple here,
the subzoning. Right.
moving forward.
No, I don't think we need the subzoning.
No, not the subzone.
I'm going to sit down. I know you had public
All right, so
comment.
can we
And
have
if you
public
still want
comment?
to
See if we
talk
have
to me.
public comment?
No.
Hold on, I got a question for you. So, which one's which? In order to get what we're aiming for, I want to make sure that under, which one comes first, the land use one or the zoning first?
The flum.
The flum, okay, under the flum then, that we accept the flum as proposed as as a mixed use. And then the zoning would go to commercial fishing under 30-694 of our code, which as is currently used, correct? Which restricts us there to commercial use and its related activities. Everybody good with that?
I know Susan's having some.
Well, I'm not saying I'm not good with it, but it's not, you just said is currently used. And that's the trigger, is that the land use map, mixed use, zoning, commercial fishing. But then you get all the commercial fishing rights to include the minor conditional rights that don't go in front of the village council, et cetera. It's no longer limited to as currently used. Only non-conforming use is limited to as currently used. I just want to make sure that's
I withdraw the sentence as currently used.
Okay.
That was for my edification.
Understood.
I can remember where the hell I was in my sentence.
Sorry.
All right, that's me trying to write and do something at the same time.
I know Van's probably. Are you chomping at the bit, Van, on this one?
Okay.
Was there, just stepping back and a question for staff, we saw a lot, and I'm a broken record on this, is that we don't just look at the goals of the comp plan that the project complies with. We need to look at the goals of the comp plan in their entirety for those that are neutral or those that don't apply. And those don't end up in our staff reports. So my question is, did the staff look at goals 5 and 6 of the comp plan in preparing their staff report? And if so, what was their analysis of the same?
Which one are we
I did.
And those are the coastal management element and the conservation element, since we were dealing with
Yeah, I did not
conservation
look
property.
at the coastal management element because I didn't consider it coastal, being cove. Let me just double check the conservation element. I looked briefly at the conservation element, but I didn't think many of the things applied, like air quality and things like that, so I didn't put it in there.
Okay.
You guys, am I dismissed for a
Public
minute?
comment.
Public comment, please.
Yeah,
Now that
we have
this
been,
up pretty good.
Van Cadenhead, Alamorada. I concur with Mr. Hammond that it was erroneously designated conservation by the first council who went through a whole lot of properties in Alamorada and zoned them conservation and failed to notify the people that owned the property. I don't want to see anything built there other than the historical use has been commercial fishing. Now, I've heard Mr. Harris just say that the commercial fishing falls under mixed use. Well, he's calling to change from conservation to commercial fishing. So what is it going to be? Is it going to be commercial fishing or is it going to be mixed use? Well, mixed use is an upzoning, and we don't want to do an upzoning. We don't want to allow someone to sell the property and build 10 houses, or even if it's commercial fishing that you all decide both the properties should be designated as, there's still going to be a back door into that for affordable housing. And whoever buys the property next could apply for affordable housing in a commercial fishing zone. So, you're damned if you do and damned if you don't. What I want to see is nothing being done. I want to see both of the conservation areas remain conservation areas, but that's in name only. That means I don't want to see anything built there. I want to see it used as it is being used, has been traditionally being used for the last 50 years as a place for commercial fishermen to do their business and store their traps and build their traps and dock their boats and anything that falls under commercial fishing. And I don't, and if you want to make a sub area, then stipulate that if it's going to be commercial fishing, it's going to be commercial fishing in perpetuity with no other building allowed there. In other words, make a special zone, and I don't think it's spot zoning because it's 50 years it's been there, and we're just trying to preserve what's been there for 50 years so that the people that are actually working on the water that need that area are able to have that area. And we don't want to put the elephant's tip of his trunk into the tent, because once you do that, once you upzone into mixed use, then the rest of that elephant is coming through. He may not be coming through this week. He may be coming through in 10 years when somebody sells the property. But don't change it now. Make a stipulation that nothing can be built there. If you want to change both of the designations to commercial fishing, but with the stipulation that it doesn't change. Tony's right. It's not conservation. That was done erroneously. So I understand, and I really appreciate the fact that you're taking this so deeply into the discussion because it is so important. And I wish you luck. Thank you.
Any other public comment? Anybody on Zoom?
No.
Public comments closed. Well, I know what I want my motion to say, but,
Go with God.
well, nobody else, I don't think, wants this, but
No,
you can vote it down if you don't like it. It's fine. So I want it to read that, I want us to recommend that they create a special area. I got the right term again? Sub-area to the flume. And by the way, we have to vote on the flume before we can vote on the other.
Yep.
We create a sub-area to the flume that limits it to the commercial zoning,
Commercial fishing,
fishing, sorry. That would be my
consistent.
motion. That we recommend that this be a sub-area to the mixed-use flume, and that sub-area be a commercial fishing sub-area.
Is that
I don't
correct?
have the exact words, but,
I second it.
ooh. I gotta say,
It met the diagram.
Isn't that what he's asking for?
no.
He's not, he's asking for the mixed use.
He's asking
and
for the
commercial.
mixed use as right, as it
Period.
states on page 32.
Only looking at the flume amendment now.
Right.
Okay. So there's an opportunity for him to, he can't say, I'm sorry, maybe this is for you, John,
This is,
but we can't, do we need to act on this motion or can I ask some questions?
no.
Okay. Is there the opportunity for us to say, like, okay, we're going to recommend the approval of this flume, and then we followed up with the zoning, they pull the zoning, and then we're just looking at this flume? Have we ever seen that? Is that something that's even possible? These two separate ordinances?
Well, yeah, well, you could always, I mean, are you asking that if, like at a future date, that they come in to rezone it to
Yes.
something else that's consistent with mixed use? Yeah, that,
Susan just answered my question.
Yes.
Yeah, okay,
What if,
That's why I want the sub-area.
gotcha, okay.
this is a curveball, I know we have a motion and a second out there, but what if we designated, since none of us can remember when it hasn't been anything other than this, and we've mentioned the word historical several times, what if we just designated a historical site for commercial fishing? Lock it down.
Wanted to improve, and if we go to this historical site, they'll have all kinds of things.
They've got
If you tried to modify anything with
billions of-
historical status on it, starting with windows in Tavernier, God forbid.
Yeah.
We want them to be able to fix things. Yeah,
God forbid they find one.
there's plenty there, but they're usually
We
fish.
probably could do that.
Oh, God.
Okay, so just to repeat it, to
I understand.
to understand, is we're working on the flume only,
Yeah.
and that I made the motion that it be a mixed use, but with a sub-area that is for commercial fishing only.
Do we need the only?
I'm good, call.
Now, council can do whatever they want. That would be our recommendation for what council would do.
the question was, do you need the only? And I would say if that's the only thing you want allowed in it, then yes,
Oh.
because in the sub area, the way the sub areas currently are drafted is they usually have like 4 or 5 things that can be
Oh,
listed.
well-
Do we need
If
to
the
say
o-
commercial?
Do we
remaining
have a,
activities?
let me pose this then. Do we have a problem with the sub-area mimicking the zoning that we're going to talk about in a minute, which is the
The
commercial,
permitted uses in
the
the,
permitted uses?
Commercial fishing and related activities and other permitted uses for such area. Does that make sense?
Yeah, I think you leave it general enough.
What I want to do, my goal, let me put my goal out there, and maybe John or somebody can help me out there. My goal is to eliminate the possibility, I know it's not a probability, the possibility of this increase of 10 market rate, that's an upzoning, or of 26 deed restricted, that's an upzoning. And it goes on to talk about commercial square footage too. So my goal is to get it to the fishing that we want it.
I see where you're coming from there, but when you take a look, when we really take a look at the upland on that parcel, it's very, very limiting.
No, I know it is.
And, and the idea of
If it
someone
was
coming,
so
the idea of
limiting-
someone coming in and saying, hey, I'm going to put, would you say 20 affordables? That's not going to happen.
But if it was, well, then guess I need to ask Jennifer, if it wasn't possible, why would we write in the report that it would increase to 10 market rate dwelling units, a possibility of 10?
Yeah, so it's the developable potential based on the FLUM, and there's different categories or different zoning districts in the FLUM, and they all have different, densities and things like that. So the FLUM has a maximum density, and so that's where I got that from.
Right.
The commercial fishing, I didn't do the specific calculation for that zoning density because we were talking about the FLUM. I can spend some time and try to figure that out, right now or later. But, the allowed uses in commercial fishing are, single family, for the minor conditional use, it's a single family dwelling unit, deed restricted affordable housing dwelling units. And then the standards are, you have to have, there's no lot coverage and there's no minimum lot area. So, so density is up to 2 dwelling units per acre or up to 15 deed restricted affordable housing units per acre. So that helps you.
In the first place, there would have to be a building put up, so because you can't put affordable housing below flood, you would have to put it on top of something. Let's just say you had a building big enough to put 20 units on top of.
Right. I mean, one side of it is only 56 wide. One is on the south side. So
I know.
and its two sides are encompassed by water. So you have setbacks that you have to meet. So that's not really a viable building section. So the only other side is the northern side, and that itself is only like 74 feet wide. So again, it's not very viable to put any of
A
these.
fish operation that needs a place to build traps.
Yeah.
Process fish.
Right, and that would be acceptable.
Great, I love a
That's
place to go buy fish.
That's covered
Right.
in the zoning, not in the flume, but
Yeah,
that is
that's in the
covered in the
zoning,
zoning.
I think that if we were talking
Says
about two
accessories.
other lots or something, to the north of it, we would be more concerned about it changing the zoning to mixed use. But this one isn't really a viable issue.
If you don't start somewhere, you don't start
I
anywhere.
hate to do this. My husband's caregiver is going to go home at 8:15, so can we call the question, or does I get to leave and not vote?
You need to be on the mic, is what she's saying. Okay, so we had a first and a second, and it was for a sub area.
It's commercial fishing.
Let's just vote, and if it votes down, then Cheryl can go. If it votes up, Cheryl can go.
Deb Gillis,
Yes.
Cheryl
Just a
Culbertson,
second, what are we voting on right now?
We're voting on the flume, and that it would have a sub-area to it that's for fishing, commercial fishing.
Only.
One vote for both issues, okay, right?
Pardon?
This is one vote for both issues.
No, that is that, it's just the flume.
Would
that
you
we're
read the
voting.
motion? Would you read the motion back?
Yeah,
for me?
please.
Do you have the motion I needed? Did you write it? I didn't.
what I wrote down is to create a sub-area to the mixed-use FLUM that limits it to commercial fishing.
And related activities, right?
Yeah, and.
And related
related
activities.
activities.
Because theoretically, somebody gets their panties in a twist, they wouldn't want you to build a trap or process it. You ain't gonna get a lot of average
Okay,
out there.
so, back to the vote.
Your yes.
Yes.
And Shirley, you go.
Yes, okay.
Patrick Foley,
Yes.
Tony Hammond,
Yes.
Lori Lalonde,
No.
Susan Raffanello,
Yes.
and James Ryan.
Yes.
Motion passes 6-1.
All right. Now we need to vote on the, Cheryl, can you say for the next vote? This should be easy. This one should be easy. We need to vote on the zoning district, which is the commercial fishing zoning district. We don't need to modify it?
Move to modify the current zoning from conservation to,
Oh, okay.
we calling it commercial fishing?
Commercial fishing.
Commercial fishing. Commercial fishing. As per the code,
As recommended.
as
As
recommended.
recommended. And she first, I'll second.
Do you have to do anything?
Oh, public comment?
Okay, thank you. Just check in the box.
Okay, Cheryl was the first,
Yeah.
and Deb's the second. Patrick Foley,
Yes.
Tony Hammond,
Yes.
Lori Lalonde,
Yes.
Susan Raffanello,
Yes.
and James Ryan.
Yes.
Motion passes 7-0.
All right, thank you. All right, moving on to the next. Cheryl, you need to leave?
My apologies, everyone,
Sure.
I have to leave.
Okay, we're gonna take a 5-minute break, and I'm not on the council 5 minutes, people.
Yeah, are we gonna take E and F together? The companions, okay. So, I'll read them both. First is an ordinance of Islamorada Village of Islands, Florida, considering the request of Ty Harris, PA agent for Island Community Church, Inc., to amend the village's future land use map from public/semi-public services PS to mixed use MU for the subject property located on Upper Matacumbe Key with real estate number 00402-900-0000000 as legally described herein, providing for the transmittal of this ordinance to the State Department of Commerce and providing for an effective date upon the approval of this ordinance by the State Department of Commerce. The other item is an ordinance of Islamorada Village of Islands, Florida, considering the request of Ty Harris, PA agent for Island Community Church, Inc., to amend the official zoning map from public/semi-public services PS to highway commercial HC for the subject property located on Upper Matacumbe Key with real estate number 00402-900-0000000 as legally described herein, providing for the transmittal of this ordinance to the State Department of Commerce and providing for an effective date upon the approval of this ordinance by the State Department of Commerce.
All right. Tony,
Yes, ma'am.
would you like to make an announcement?
Sure. I am going to recuse myself on this vote, obviously, since I'm still very much involved in the organization and serve as an elder, which means I'm a board member of what is taking place. To give you a little brief history on this, when I was a kid, I changed the marquee at the Santa Monica Theater. It was built in 1958 by Gene Rodas. We purchased it in 1974. The last movie that was played there, I think you have a photo in your packets. The last movie, as I remember, was The Godfather, if you look on the marquee. So since I knew how to change the marquee, as soon as we purchased the property, I climbed up on the marquee and changed the sign to say God the Father. And we moved in the next week. And somewhere along the line, because it was a church and school, the zoning changed from the commercial use as as Santa Monica Theater had been all those years to what it is now. And so when we caught that, I went to Trevor, who is now the senior pastor and president of the organization, and said, we need to talk about changing this. So that's where we are.
All right.
All right, so again, this is Island Community Church, Inc. They've submitted a request to amend the FLUM from public, semi-public services to mixed use, and the zoning from public, semi-public services to highway commercial. The church is, obviously, it's currently a church, but they're moving their location from this property to the former Island Christian School. And then they would like to change this designation to repurpose the building into a commercial activity. The property was formerly, as Mr. Hammond had so eloquently spoke, was previously movie theater, the original Islamorada movie theater. And when the church purchased it in 1974, it was zoned under the county zoning as suburban commercial. When the village incorporated again, the zoning was changed based on the use to public, semi-public services. So the subject property is currently, like I said, zone FLUM. The FLUM is public, semi-public services. The surrounding properties to the south are designated residential medium FLUM. To the north, the adjacent properties are designated residential medium and mixed use, including the public supermarket. The properties to the west are designated residential medium, and to the east across Overseas Highway and the Old Road are designated residential medium. The character of the subject property is an existing church building and associated infrastructure, and the surrounding area is mixed use with a collective of retail businesses, multifamily apartments, and single-family residences. Again, the existing zoning is public and semi-public services, and the flood zone is zone AE7. The surrounding zoning, the adjacent properties to the south, are designated residential single-family R1. To the north, the adjacent properties are designated residential single-family R1 and highway commercial. The properties to the west are designated residential single-family R1, and to the east across Overseas Highway and the Old Road are residential single-family R1. The property itself is 32,000 square feet parcel in Upper Matacumbe. The property contains no significant habitat and mostly devoid of all vegetation. The property is not recognized as any habitat on any state or to any state or federal listed animal species, and it's not within the state conservation recreation lands boundary or critical habitat area. And pursuant to the village's GIS map and data, the records and of the parcel is not defined as any specific habitat. Again, the analysis is in your packet for both the FLUM and the zoning. Happy to go through that, but again, Mr. Harris is here to present a presentation.
Good evening. Ty Harris again for the record, 110 Plantation Shores Drive. So I know what I'm going to hear from Ms. Sharon or Susan. She's going to say, upzoning. We're upzoning this property, and she is going to have a problem with it. That's okay. But there's also a counter argument, which is we already have a building on a built site. I would much rather see that we direct redevelopment or new businesses coming in to use existing buildings rather than tearing out hammock or green space on vacant lots. And the only way you do that is give them new life. And how do you give something like this new life? You rezone it to an attractive category that's consistent with what's around it. And so our request is consistent with what's around it. This is really kind of the beginning, in my mind, of the kind of tourist corridor. It's a perfect building for somebody. So why would we not want it back on the tax rolls and being reused? I mean, part of our mission statement says protect natural resources. Well, the first way you protect natural resources is you reuse what's already there. And this is a perfect example. It's kind of interesting. At least we know why the village did what it did, because in the village's mind, when you have institutional and religious uses, you zone them and change the flume to public service or semi-public service. The fact is nowadays you don't do that anymore because there's something called RLUPA, the Religious Land Use Protection Act. And RLUPA basically allows these same type of institutions to be in almost any zoning category. So we don't have the days of yore when you had to kind of change the zoning, and then when a church moves, grows, relocates, all of a sudden you've got this building that has very limited uses allowed because the use that it was then tailored, the zoning was tailored for, is now gone. So I've presented the data and analysis, and basically based on the number of deed restricted affordable units that the village is going to pick up, in there's a formula for the number of commercial square footage that has to be available to support those new residential uses, and it's a little over 70,000 square feet. So, Susan, for the data analysis, it comes from the adoption of the 300 affordables and the ratio of commercial that is needed according to the state to support that new residential use. So I'll answer any questions that I can answer, but this is also kind of a straightforward one. I know, like I said, I think I know where Susan's going to go with the upzoning, and I understand that. But it's also a chance to reuse a piece of property. Thank you.
Anybody around the table?
Susan, you want to start?
Susan, would you like to start, since he called you out?
I will indeed. How much vacant public service, or what is the proper name for this? PS is what I always think public service, but I don't think that that's the appropriate acronym. How much of the zoning vacant PS do we have currently in Almirada?
I didn't do that calculation, but if you want to wait a second, I can quickly do it while you're talking.
Okay, because I think that is, along with some of the data that we heard from Ty, the analysis needs to be that we need more of one and less of the other, especially if we're going to upzone. And currently we have a significant amount of, I think the percentage is around 15% of vacant commercial land. And while I absolutely agree with the infill when When appropriate is another objective, obviously, of planning. You want to infill before you use vacant land. We have a lot of commercial property that is available right now, and I don't know how much we have for PS.
Give me a few minutes.
Well, let's talk about PS. I mean, PS is primarily where you find your government facilities. And so I know there was discussions many moons ago about the village purchasing this property, and then nothing came of it. I don't know how those discussions go. That's outside my pay scale. But I do know that if you're going to repurpose the property, you want to give it the best chance of success. And you want to be consistent with what's around it. And so the zoning and flume requests are consistent with what's around it and provide for the best opportunity for the church to sell it, and for the use to be consistent with what's around it.
Well, what we're looking for, though, is what's the best needs for the village, as opposed to the highest and best purchase price that the church could get.
Well,
And my question is, we have here a situation where, to my understanding, that after Hurricane Irma, there was no other place for the village hall really to go, which is how it ended up in Founders Park, or on the other side, right over there at Founders Park. We have fire stations that have significant growth issues, and other municipal facilities, schools. We have the increase in population that even the 2011 study you provided shows. So we need to make sure that we are able to meet all of those obligations. And frankly, one of the issues that I have, in particular with the schools, is that study was done prior to PKS being finished. And when PKS was built, they expected that school to have sufficient space for K through 8 into the future. And guess what? It's maxed. And it's primarily maxed by those in district. They were even contemplating having to bring trailers onto PKS, a brand new school that was completed. So there is a need, I think, for areas, for churches, for schools to accommodate the public use. And when we get the answer to how much of that exists beyond this church is a significant data point for me.
You know, the church is also a part of the community, and the church
Absolutely.
the church has a right to come ask for a change in zoning.
Absolutely.
They're no longer using the property for what it was used for decades. And so they are exercising that right, and it's consistent with what's around it. You know, as far as public service goes, like I've said, if you're talking about religious institutions, you don't need to change the zoning. You can go into industrial now. I mean, that's federal law. So if you want to put a church or religious institution up, we're not even having this discussion, our purview. It's only when you're undoing that because there's no longer a need for that facility at that location that we end up having this discussion of how do you repurpose, what's consistent with what's around it. Are we taking away available land for something else? I can tell you that any governmental agency that buys a piece of property will get their correct zoning to use it the way they want to use it.
Well, but at the same time, now we have changed the zoning that exists currently. So I absolutely agree. Property owners have the right to follow the procedures set forth to request a change. But the only rights a property owner has, any property owner, I'm not calling anybody out, is what exists now. And so they have the right to ask for a change, but we have the obligation to evaluate the change. And you're right, I am concerned because it is an upzone. And the reason I go back to that is the village code says that we got to be real careful when we're upzoning.
And that's why when I mentioned in my presentation, it was because I knew that was a concern, and you've been very consistent always about that concern. So I expected nothing less than to be asked that question and for us to have this discussion about is this the best use of the property. But I also don't want it to be in the situation like we saw in the application before. That property, everybody agrees, was turned into conservation when it had no business being conservation. So why was that done? Well, the most plausible example, and I know, Susan, we don't have it in the record, was because the government wanted to buy the property and wanted to decrease the value so that they got a better price. So we don't want to do the same thing in this situation. If the government wants to buy this property, then they can buy it for whatever the price is, but that's not, you don't want to deflate the value by not allowing an appropriate request to go forward. That's my concern.
I understand, but even the staff indicates that, which is why one of the reasons I asked the question, it shall ensure that PS land use designation on the flume is sufficient to accommodate increased needs for these uses. So that is a concern, obviously, as it was announced by staff that they're going to continue to monitor it. That is a concern of the village that we have those designations. And once you make a designation and you upzone it, you don't downzone it without significant risk, as you've pointed out in your presentations.
But you also, it's not appropriate for the government to warehouse prospective properties for future use by the government.
But this
and
is
by keeping the zoning in place that only allows essentially government uses on the property, government or religious uses. So, I mean, if the government wants the property, the government, since at least 2018, was having discussions about buying this and did not avail themselves of that opportunity.
But then you go back to the fact that we have incorporated, and that was done 20 years ago, and you can't expect people currently to look back and say, oh, well, that was an inappropriate intent 20 years ago. Instead, I think to evaluate these issues that come up for what was then and what is now is a comprehensive comp plan review so that we have all of the information in front of us. And we have talked about that since before I was on the LPA, which is not all that long, only a couple, 3 years. But we've talked about wanting to do that, and it doesn't go anywhere. With the strategic growth, and we're supposed to do it every 7 years. I know, we're supposed to do it every 7 years, and it hasn't been done, I don't think, for the last 20. Instead, we're piecemealing amendments, and that is not a criticism of you or the property owners. It is more a function of, it is very difficult to sit in this chair and say, without having the full picture in front of you, how much land we have for each use and whether it's appropriate. And because we have not done that is what drives my concern so much about upzoning, because once you upzone, you don't get it back down.
Well, and my concern is that, for this particular zoning category, it's tailored to government uses and religious institutional uses. And that's a very small group. And the properties that are zoned that way are being used that way. So if it's not going to be used that way, it shouldn't be zoned that way, because that smacks of warehousing property for speculative use down the road without just going ahead and buying it. And like I said, since we know in 2018 there were discussions about purchasing this property, I'm not good at math, but 18, 19, 21, 22, 23, 24, 7 years is a pretty long time for there not to be any action.
But it was zoned that before. I mean, so...
But it was also zoned for a theater before.
Well, under the county.
But here's the thing. It's okay that over time the demand for things change. And in this case, what's being asked for is consistent with what has developed around it, which is commercial. So commercial is the consistent use of the property. It's not an overreach, or it's not an over ask. It's consistent with what's around it. So, I mean, this is one of the things that makes this fun, right? And it never stops, because there's always change. There will always be change.
I have a question.
Jennifer, do you want to give your, hang on just.
So we have 34 total lot zoned PS, which is 0.005% of our total lots. 9 of those lots I looked at to be vacant, which is 26% of the PS lots. Keep in mind, though, that some of those are owned by Monroe County or privately owned by, or other agencies, or privately owned by churches and things like that. They're not all owned by the village. I just want everybody to understand that. And I just wanted to address your concern, I think, or maybe not address it, but just speak to your concern about overarching review of the comp plan and overly amending the comp plan. I'm currently working with the finance department to issue an RFP for a consultant to go out for that process to do a complete overhaul of our comprehensive plan. So that process is in the works for this year. I just wanted to be clear about that.
sorry, the 26% available, how many square feet is that?
I don't have that number. I won't be able to get you that number tonight.
Couple questions I have for you. The building as it stands, and I've been in the building, it's a very unique building, and what condition is it in? What is any future uses of that include a tear down of the building and new building up, or would be more likely to be refurbished? And
I think that there have been a number of people that have been in and out of the building that have, different opinions on whether it's a complete interior remodel or a complete tear down. And I guess it just depends on the use. Pastor Tony probably has a little more direct knowledge on that. But I do know that if you're going to change the building, it has to come up to new code. And that's how we always end up upgrading the buildings, is because when you come in, you start making renovations, then you have to bring it up to code.
now, and my second question is, I know Publix recently built a giant store down there, and what if Publix decided that they wanted to put a little grocery store there? Would they have an easier time getting this committee to approve that than the past?
There's a provision in our comp plan that says that any building, now there are some exceptions for hotel uses, any new building can be no larger than 10,000 square feet. That was the Publix provision, because basically if you see a Publix or any of these other buildings, they're much larger. I mean, I think the smallest Publix footprint I've ever come across is 35,000 square feet.
That's ours.
So what is
Ours. 30, I think ours is 34,000.
Yeah, come on, I'm rough math, 35,000
just
square
saying,
feet.
that's hard.
So that's the smallest footprint as they'll do. And so the reason that provision was actually put in was to keep another Publix out, or another big, what they call them, big box stores. And so 10,000 square feet isn't enough box for any of these guys to squeeze into. And that's why you haven't seen any more applications by Publix. Probably why Publix is trying to get into Tavernier right now.
No, the point I'm trying to make is that I know Publix mounted a all-out effort to move into Islamorada, and it was an all-out fight between citizens and the village and Publix to get that there, and they managed somehow to get the zoning changed so that they could put that there. And we have
They didn't have a
church that's
zoning
been here-
change. They have no zoning change.
Okay, but we have a church.
It is a site plan. It would have been it was before I got here, but it was a site plan change, yeah.
Okay, but we have a church that's been here for a long time, and they're asking just to be able to,
Reuse it.
utilize their property in some manner, and maybe we should give some historical consideration to those members of our community who have been stewards.
Right, and it was commercial before, and that's the thing, is that over time things change, and you have things that are going to come in. There are probably uses that we haven't even contemplated. I'm thinking about one right now: charging stations for electric vehicles. Discussion we've been having. Maybe we need to do something in our code to start encouraging those to come in. As we look at these multimodal transportation issues with buses and kind of getting away from gas-powered vehicles. So, but 25 years ago, nobody had ever heard of Tesla or electric cars being anything more than somebody, rich person's little thing they drove around and went back to their garage. And now our code didn't contemplate that. So the code is always going to be, to some degree, a living document. It's always going to need change, and people are always going to come in and ask for stuff based on what the market is like and changes of uses. So that's what makes what you're doing exciting, because you're at the front end of it. You get to see it. And you're right. I mean, it's time for the comp plan to be updated. The comp plan is not that bad. It doesn't need as much work as you may think. It's the zoning code that probably needs a little bit of repair.
I have a question. In PS, does that include fire stations, police departments, libraries?
That's all the public service.
Any public government building.
Yep.
Okay.
And I know that tomorrow on the agenda, at least I saw, when I
Right.
looked at the city council agenda, there was a proposal to have a library go in there. So that's
I saw that too. The funny thing is nobody's talked to my client about it.
really,
No, we had no,
that was kind of, now why are we still going forward with that? But anyway, that was just my own thought process.
I'm
when I
not,
saw
I'm,
it.
Talk
my
about
direction is to-
obsolete. Who needs libraries now?
Yeah, but the one in Marathon is.
may I make a comment?
Sure.
So, as some of you know, we had a buyer potentially buying the property who backed out at the last second. In the process, I was asked, well, what's the zoning on the property? I said, it's commercial. And then we found out, no, it's not commercial. And so we found out that, well, there had been a whole move to get the council to approve changing the zoning from where it is now to what we're requesting. And that was our tip-off. So we're not asking to upzone. We are saying, wait a minute, we were downzoned without knowledge. There was no letter. Listen, I have every piece of correspondence I believe that ever came through. And I've spent hours as we've been moving from the existing church building over to the new facility, looking at every piece of documentation I could find. I've sent Ty every piece that I could.
And this is the thing. I haven't looked at the statute a long time ago, but in 1996, if you were changing the flume or the zoning on 10 acres of land or greater, you did not have to send individual notice to property owners. It was only noticed by publication. So when we talk about all these people that become surprised that their property zoning changed, it's because the village did everything correct by the law. Did they do everything correct that you would want your neighbor to do in going, hey, we want to have a conversation about your zoning, and we're going to send you a notice. Whether legally they did what they were supposed to do. But I called that, when I was in Jennifer's position, the first sin of the village is that they didn't let people know that they did that, and it created distrust, it created problems, it created hardship. I mean, we had people that were trying to sell their property that thought it was commercial. They still thought it was suburban commercial in the county, who were retiring and find out that their property had been zoned to a residential category they couldn't use. And that was the money that they were banking on that money to retire on, and having to have those conversations and to check to see that was there a mapping error, and not finding a mapping error and say, no, it was actually rezoned on purpose to this. Well, I never knew that. It's been 25 years, I never knew. But we are all living that because of those decisions that were made then. For good or for ill, those are the decisions that were made. But by not giving people individual notice that their property was going to have a change in zoning, that created a lot of problems. And those problems we're still dealing with today, and we will continue to deal with them.
And if someone
And so
came and said,
you
that's-
only recently learned that it had been, perhaps because of what Ty was just explaining, the church only recently learned that it was not commercial. It always had the expectation when it sold the property that it would be commercial.
Absolutely. And if someone had come and said, we are anticipating changing the zoning, by the way, this will limit your gene pool in terms of the number of buyers in the future potentially, and also it will devalue your property, which is why the previous potential purchaser was trying to get the zoning changed, because it was a significant increase, would have been of value to him to resell or to do whatever he wanted to do with the property. And I said, well, wait a minute. What's going on? How did this happen? As a 26-year-old school administrator, if someone would have come in and said, oh, by the way, you have a church, you have a school, we want to make this change. We probably would have said, oh, okay. Now, if someone would have said, but this is going to have this impact on you in the future, we said, oh, let's wait a minute, let's have a conversation about this. That never transpired at any point, at any time. And since I was there from the very beginning, from day one, and still there, I can tell you that never took place.
And that's part of what we talk about. And Susan, you're absolutely right. The village had every right to change the zoning. But what's what's legally done versus what if you care about your neighbor and you know, what you should have done was say, everybody that we're going to rezone, this is what we're proposing, and this is how it changes your existing uses and rights. I bet you there would have been a lot of pushback on a lot of those rezonings. So even though it was legal, whether it was done and it was the right thing to do is a question in my mind. And it's something, one of the reasons when you look at some of the things that I did as a director based on things like that, where I thought that people really got a raw end of the deal and it didn't make a lot of sense. And when I got that phone call from the 75-year-old lady who was trying to sell her property and thought that it was commercial and was bawling in my office with Mike Forrester there, and I'm checking the maps and there's no mapping error, I felt about this big, and it was about the one time I felt embarrassed about working for the village, because it wasn't right. It may have been legal, but it wasn't right.
Sure.
And we hold ourselves to a higher standard. I mean, we're a small community.
So let's jump to public comment, and then we'll come back to the table. Public comment? What? Van. Oh, my goodness.
We have no one signed up nor on Zoom.
All right, back to the table. Continue the conversation. You have a comment?
I make a motion to accept the Flummin zoning change
One at a time.
as it's stated.
We have to do one at a time.
Oh, one at a time?
Yeah, I was going to say, can we split those up?
Sure. What are we going to do? The want to do the
We have
Flum
to do
first?
The Flum first.
Okay, so I make a motion to accept the Flum as presented to us.
I'll second.
I have a first and a second. Roll call, please. Or further discussion? Sorry. Nope, none.
Lori Lalonde,
Yes.
James Ryan,
Yes.
Patrick Foley. Susan Rathbella.
I think I think it's in the, but so I don't have to read it. This is in the VAC, right? This is in the Village Activity Center? This property? Okay, yes.
Does Cheryl get to vote? She's on Zoom? No?
She can vote if she's on Zoom, yeah.
Okay, she doesn't have her hand raised. Cheryl Culberson. I don't see her turning yet. Yeah.
She probably got pulled off.
Okay, so motion passes 5-0.
Forgot
now?
Deb.
Can you hear me now?
Oh, there's Cheryl.
Yes.
Yep, yes. Thank you.
Okay.
And I vote yes also.
Thank you.
You're welcome.
Motion passes 6-0
All right.
with one abstain.
The next is the zoning. You
So
will-
I make a motion to accept the proposed zoning change.
I'll second.
Okay, we have a first and a second.
Lori Lalonde,
Yes.
James Ryan,
Yes.
Cheryl Culberson,
Yes. Yes.
okay, Patrick Foley. Susan Rathbella
Yes.
and Deb Gillis.
Yes.
Motion passes 6-0 with one abstain.
All right. Moving right along.
As a reminder, G and H were,
G and H were pulled. So we're down to I,
yep,
correct?
I and J, which you guys want to take these
Yes.
together as well?
Yes.
I think. First, I'll read them both. First one is an ordinance of Islamorada Village of Islands, Florida, considering the request of Windley Cove LLC to amend the village's future land use map from residential medium RM to mixed use MU for the subject property located on Windley Key with real estate number 00405-350-000000 as legally described herein, and to allow the parcel to be included in policy 1-2.11.3 Windley Key Mixed Use Area 1, providing for the transmittal of this ordinance to the State Department of Commerce and providing for an effective date upon the approval of this ordinance by the State Department of Commerce. The second is an ordinance of Islamorada Village of Islands, Florida, considering the request of Windley Cove LLC to amend the official zoning map from residential single family R1 to highway commercial HC for the subject property located on Windley Key with real estate number 00405-350-000000 as legally described herein, providing for the transmittal of this ordinance to the State Department of Commerce and providing for an effective date upon the approval of this ordinance by the State Department of Commerce.
Probably should have asked this before John did all that, but since the other two are the same applicant and the same exact request, do you want to discuss all four at the same time, or do you want to just separate the two?
It's okay with me if we do all of them together, if it's okay with John.
Yeah, that's fine. There'll be separate votes, but we
Yes.
can discuss them all. Let me read the other two as well.
Thank you.
Let me pull them up. The next one is an ordinance of Islamorada Village of Islands, Florida, consider the request of Windley Isles LLC to amend the village's future land use map from residential medium RM to mixed use MU for the subject property located on Windley Key with real estate number 00405-360-000000 as legally described herein, and to allow the parcel to be included in policy 1-2.11.3 Windley Key Mixed Use Area 1, providing for transmittal of this ordinance to the State Department of Commerce and providing for an effective date upon the approval of this ordinance by the State Department of Commerce. Then the last one, hold on, let me pulling it up here. Is an ordinance of Islamorada Village of Islands, Florida, considering the request of Windley Isles LLC to amend the official zoning map from residential single-family R1 to highway commercial HC for the subject property located on Windley Key with real estate number 00405-360-000000 as legally described herein, providing for the transmittal of this ordinance to the State Department of Commerce and providing for an effective date upon the approval of this ordinance by the State Department of Commerce.
Thank you. So these are applications by Windley Cove and Windley Isles LLC. Both are represented by Jocelyn Tiedemann, who's here this evening. They are the two brand new homes being constructed next to Hog Heaven, if you're familiar with that area. So they are currently zoned residential medium, the FLUM is currently residential medium, and they are zoned residential single-family R1. She's requesting that they both be changed to the mixed-use FLUM with a highway commercial zoning district. The purpose, her intention and purpose for requesting this change is to pursue acquiring vacation rental licenses for both properties. Currently, a vacation rental license is not allowed in an R1 and a residential medium FLUM, but is allowed in a mixed-use FLUM. So both properties are, so in order to accomplish this as well, she had requested it be also included in sub-area Windley Key Mixed-Use Area 1. After reviewing that, I believe that the appropriate mixed-use area would be Windley Key Mixed-Use Area 2, which limits the development potential to single-family home. So reviewing all of these, the subject properties, again, are existing residential medium FLUM. The surrounding properties to the north are also designated residential medium FLUM. To the south. To the north, the adjacent properties are designated mixed use, and the properties to the west across Overseas Highway are designated conservation, and to the east is the Atlantic Ocean. The character of the subject properties are single-family homes with some mangrove wetlands to the east of the property, and the surrounding area is mixed use with collection of restaurants, marina uses, single-family residences, and conservation land. The zoning, hold on, sorry, I have to switch back and forth. The Subject properties currently have residential single-family zone R1 zoning district designations. The surrounding properties to the south are also designated residential single-family R1 zoning, and to the north, the adjacent properties are designated highway commercial. The properties to the west across Overseas Highway are designated as conservation, and to the east, again, is the Atlantic Ocean. The character of the properties, again, are single-family, and the surrounding areas mixed use with a collective of restaurants, mixed uses, marina uses, single-family residences, and conservation land. There, again, there is analysis in your packet of all the property. Ms. Tiedemann is here this evening to give a small presentation if you'd like to hear from her.
Hi, I'm Jocelyn Tiedemann, 127 Coconut Row, Tavernier. I know you're all tired. I'll be brief. I'm not as good as Ty, so I'll try my hardest. As you guys have all seen, probably these properties being built over the past 2 years are my babies, are my heart, my soul. I'm there every single day. I drew the plans. I did all the permitting. I'm there consistently. Winley Key, obviously, you know, is almost strictly all commercial and tourism. I think there's only 6 R1 homes on all of Winley Key. There is very, very minimal homestead properties at Winley Key. Everything else is, you know, condominiums or, again, commercial. So if there was ever to be a property, I think, which are adequate for vacation rentals, these are excellent sites. I'm sure everyone is familiar with Hog Heaven. They are open till 4 a.m. They do get a lot of traffic. These aren't really homes that are compatible with long-term occupancy. I think vacation rentals would be very suitable and very fitting. Before the village was incorporated, these lots were zoned suburban commercial as well. So kind of following what we just previously, or Ty talked about. So they do have grounds to, you know, previously been commercial properties. I don't think this would be called upzoning, considering that they are still going to be strictly residential homes. There is no change of density. There is no change of intensity. There is no commercial use, and there's no businesses other than the allowance of vacation rental. Talking about a sub-area policy, there is already a Winley Key sub-area policy next door, which Hog Heaven went through this very same process of getting their zoning changed to highway commercial and flume mixed use. They did that to add, I guess, accessory structure in their parking lot for Hog Heaven, which was done a couple of years back. So we are just going to be continuing and staying consistent with the zoning to the north side of having highway commercial and mixed-use flume. I know everyone's always concerned about, you know, property owners around the property if they approve. I do personally own the property to the south side of these two properties, so as the adjacent property owner, obviously I do support what I'm trying to do. I'll try not to talk too much. I know there are still, you know, remaining it's about approximately 60 vacation rental licenses that aren't being occupied and used right now. Again, this is not a residential neighborhood, so I do think it would be a very excellent site and, you know, a positive for the Village of Islamorada. I think that's about it of all my key points. I am definitely here to answer questions.
Thank you.
Yes.
Okay, so I'm going to start it off with the first question because I was having trouble finding it and I should have been able to find it. What is the difference between WKMU-A1 and WKMU-2? Because staff recommended that you think 2 is more appropriate than 1, but these applications were written in 1.
Yeah, I'll take the blame for that. Jocelyn came to me, and you may recall this was going to be before you previously, and then it was pulled. And part of that was because Jocelyn and I had a conversation about the sub areas and moving forward in that regard. And initially, we talked about the sub area number 1, but then when I relooked at it, my thought was the sub-area number 2 would be more appropriate. So I'll take the blame for having Jocelyn apply for number 1, not Jocelyn. So, but the number 1 is, it allows for a higher density. It allows for 2 market rate units, 15 affordable housing per acre, and it also allows for hotel motel units. The number 2 limits the development on the property to one maximum of 1 legally established residential dwelling unit.
Okay. Perfect. That was my main question. This, in my opinion, isn't a true upzoning because of the fact that it's the sub-area.
Yes, ma'am.
Okay, so what else? Who else? Go ahead.
Yeah, may I make a comment?
Sure, go ahead.
Jocelyn, your house is, the design is beautiful. I admire anybody that thought they could put something in front of Hog Heaven. I would like one caveat. I don't have a problem with you changing that, but I'd like to make sure that the occupancy does not exceed 15 people, which would be a little bit much in my book, but it's no amplified outdoor music so that it doesn't turn into a wedding venue. Not that I think anybody wanted to get married next to Hog Heaven, but I have been to a wedding there before, and it was loud. That would be my only caveat. Other than that, they're beautifully done.
Thank you.
But I think vacation rental makes a lot more sense.
She wants to limit the occupancy in houses.
Okay.
That's what she
So
said.
our vacation rent, if she were to get a vacation rental licenses, they're limited to two occupants per bedroom under the vacation rental license
Okay.
policy.
It's 4-bedroom.
Yeah, well, wait until the SAE fraternities rent the house down the street from you. See how many show up.
Okay. Yeah, I'm
Just
having a hard
talking
time
about,
understanding.
yeah, if you had an event that's different, but the actual occupancy of the house would be.
Okay.
If there was a wedding on the property, that would be different, right?
I mean, I think everyone
It's
is
an
allowed to
event.
do weddings. I mean, I'm not saying that this is going to be a wedding venue whatsoever, but I don't see the need of restricting some additional way that way. I just don't see how that affects.
Well, the occupancy of the house is.
Okay,
is
I understand
the
that.
vacation rental, so it's already restricted in that, as long as you understood that.
Okay, of course.
Okay.
So, and any wedding would require a temporary use permit from the village, which we would look at occupancy, and the fire department would have to review that as well.
But that's if they have more
If
than
they
100,
get the vacation
100
rental
people.
license.
But
No,
even with the vacation rental
we've had an opinion
Policy
from
aside
our
from
legal.
wedding with just your family versus 100 of your closest friends.
So we've had an opinion from legal counsel that temporary use permits are required for any special event, not just 100 people.
Oh, really?
100 people triggers a separate set of reviews, but if you read our code, legal counsel has determined that it's for any event.
Okay, so what you're telling us now is that we're having a street party down at the end of the street or somebody's neighborhood park and
Oh, that's not what I'm saying. There's a very specific definition of a temporary use, and weddings would fall into that category, but your family party would not, so.
family party not. Okay. So you're not getting married, you're just having a family party and you
just happen to say, I do.
Yeah, just don't invite 100 of your closest friends.
We're getting crazy. It's time to go home. Okay.
I am on my way.
Are your comments finished, Cheryl? Susan would like to
Yes,
make
I'm fine. Thank you.
Okay, thank you.
Well, I do think this is a real upzoning. We're not in the Village Activity Center, which is where our commercial focus should be. And I believe there's even a requirement in the code that if you're outside the Village Activity Center, you are not to upzone it if it may have a potential negative impact. Here, I do see that there is a potential for negative impact. we are not, the staff's report says pursuant to section 30-696, the purpose of highway commercial zoning district is to accommodate existing businesses along US 1 and provide opportunities for new commercial retail shops and services that are typically auto-dependent and are used by people on less than a weekly basis, and so on. That's not a vacation rental. These properties were built single-family homes because they were zoned for single-family homes. There is no benefit to the residents as a whole of Village of Almirada to upzone this property to highway commercial to allow for vacation rentals. That is a private property owner upgrade that doesn't have the nexus that I think we need to upzone property, which is, do we need more commercial properties? And the answer is no. And the answer, though, that we got is, but these aren't really going to be highway commercial properties, but they are as soon as we zone them that way. That's what they'll have all the legal uses to be. And they are on the old road. I mean, it's hog heaven. You've got an argument that cutoff is close enough. These are old road, which is why I presume they're under Windley Key, but they're not on US 1 and they're not in the appropriate corridor. So then we have, other organizations, but I just don't see where the criteria and the data have been met in this particular application for just to upgrade, just to allow a change just so a vacation rental can be had, when we now have to change the zoning entirely to highway commercial. They're beautiful homes. They can continue to exist as such.
I have a question.
Yes, sir.
When did you decide to make these vacation rentals?
I've had them listed for sale. I pulled the listing. A few people that have came to see them gave negative input about being, so close to commercial. Of course, the thought was always there. It's either you're going to love the location or you're going to hate the location. But so far, most of the comments I have heard from prospective possible buyers is this is not somewhere I want to live long term. And it was a really kind of like a shot in the dark on how people are going to feel about these. And as I kind of collected more comments, it just kind of made more sense to me throughout the construction process. I have been working on these for 2 years now, that it would be probably better served as vacation rentals.
So this was an evolving.
Definitely. Yes, sir.
You originally planned them as single-family homes?
Yes, sir. 100%. Yeah.
And later on, when you found that they would not work perfectly.
Yeah, I'm a realtor too, so I've invited colleagues over there to see them, and there's been multiple comments. These would be served much better as vacation rentals. We don't. It's just collecting data as they went up and having more people there.
Can you rent these out at longer term without changing the zoning?
It'd be the 28-day minimum rental period is what currently allowed.
Staff recommended approval on all of these, is that correct?
Yes, with the sub-area approval as well.
Yeah.
Yeah, I did figure, there was some precedence of just, again, the adjacent property went through the same process and did this sub-area. This sub-area is definitely even much more restricted than what Hog Heaven did, as they had, some commercial accessory structural use. And again, this is strictly one residential home, so nothing changes whatsoever. Someone could very well live there with 8 occupancy full-time as someone renting it with 8 occupancy. It'd make absolutely no difference on water usage or anything. If we're limited to 8 occupancy, which is fitting and I think it should be, I don't see any difference.
I do think there's an increased intensity associated with vacation rentals, though. It's the nature of the beast. You have a long-term family or even a 28-day family living there, that's one thing. But unfortunately, we even see it with house sharing, it seems, with Miamians these days. But you have somebody who comes down for a week and they are going to make the most of that property, and they're going to pack in the property as much as they can. Whereas a single family probably is not going to have 2 people per room. For a long term, you can bet the vacation rental will, and more than one family, to make the cost up. It's just how vacation rentals go.
Okay. I've personally never dealt with vacation rentals 100%. But I mean, I definitely understand that.
I've rented them, and I usually do with 2 or 3 other couples. So,
But I mean, location-wise, I mean, I think there is a general census that everyone could agree on that this is more appropriate as, you know, not a long-term occupancy location.
I'm not so sure the neighbors to the south would agree with that.
Which is me.
Well,
And
no,
I've
but you
spoke
have the lot
to,
next to it, but there's-
I spoke
there's
to my
3 other
next
homes.
Yeah, I know. I spoke to my neighbor Beverly, who lives on the other side of my vacant land lot. She 100% agreed, gave her approval. I spoke to the gentleman who lives 2 doors down, who owns those 2 properties. He gave his approval. He said he wouldn't want Beverly to do it next door, but he had no objection to me doing it on my 2 lots. I've spoke to the man who owns Hog Heaven on that side. He has no, you know, he wants it as well too. So every one of the RM1 properties I have spoken to, and they have said they had no problems with it.
So the lot that you purchased on the south side, that also has a building, right, correct?
Yes, it does.
So that you're gonna then come back towards this and ask us probably for the same.
No, I want to live in it
consideration.
myself personally. Right now is definitely 100% the goal for me to live there. Yeah, I'll probably only live there a short time. Just I'm not that oceanfront girl, but you know, my plan is to build in it, live it for a couple of years, and then possibly sell it.
So going forward, when this, one way or the other, when this goes to council, can the change in, assuming she's willing to do this, can it simply be changed from the WKMUA 1 to 2 as it should have been? Or does council have to, can it be presented as council as a 2?
Yes, it will be, yes.
So it will be changed
Correct.
to read 2?
Yes.
Okay, that was my question. James, you got anything?
I see, you know, what the applicant's asking, and I also see, you know, what Susan's saying about getting rid of these residential areas. I'm just trying to, I'm trying to think right now. It's getting late for me too.
Well, I do know that, and it's not specific this, but we have, over the years, tried to find vacation rental properties that seemed suitable, whether that's a large estate that's back away from everything or already in an area that has vacation rentals, to not invade a neighborhood that doesn't have vacation rentals, to explain that a little bit. At the same time, we all know that they're out there, they work very hard at trying to find them. There's illegal vacation rentals, and this one's trying to be legal. And she's restricted what she, from what is it is an upzoning because of the way the future land, the FLUM reads, but it's got the subset that brings it back down. So the only thing she can do is what she had, except now she could do vacation rental.
Yeah, when I first looked at it, it was definitely, I thought it was a great location for it, just as you said. And I liked the sub-area change to where it wouldn't be, you know, the multifamily or the 10 different units. It was going to be the one single family and then vacation rental. And, you know, the Smuggler's Cove used to be across the street. I mean, it's not there now, but we have the Hog Heaven. It's, I think, a good area for it. You're right. But at the expense of getting rid of more residential, it's a scale there.
But it's not low, it's not a low-end residential. If it stays residential, as it is now, it's a high-end residential.
Yeah.
If there's a distinction in whether we're getting rid of housing.
I want to commend you for doing this correctly,
Thank you.
because I know many people who have illegal vacation rentals, and you're doing this the right way. So.
Yeah. I think that's the good point, too.
I mean, it's definitely not your typical residential neighborhood. You know, you don't see kids playing in the streets. You get cars zinging by at high speeds. It's, you know, not your general neighborhood.
I would just wanted to ask a question to staff.
Yes, ma'am.
With the change in the flume, I thought I heard you say that only allows for one single-family home. Does it allow for the highway commercial zoning? And how does that connect together then?
So
If you can only have a single-family home, which is not a use that would typically be seen under highway commercial,
It's allowed in highway commercial.
it's allowed, but so trying to meld together. So you usually have your flume, which has more uses than your zoning. But I thought I just heard you say when you changed from 1 to 2 that you could only have a single residential home there.
So this sub area is specific to say that the density only allows for one single-family residence.
Okay, and no commercial establishment then?
No.
Okay, so now we're taking a residential flume map amendment and we're going to overlay it with a zoning of highway commercial, which is designed for, as I just indicate, along US 1 commercial corridor for retail, motels, hotels, and things of that nature.
Mm-hmm.
That seems odd.
Okay. I don't know.
But what you're saying is highway commercial is an approved zoning for the M whatever classification 2. It falls under the umbrella.
The sub area is, it's just, any property can be in the sub area, right? And it doesn't matter what the flum can be whatever. That doesn't matter.
Okay, so we're still looking at a flum change to mixed use.
Correct, but then you're further restricting that flum by the sub area of the Winley Key mixed use area 2, which limits the density to one single family residence.
Okay, and that sub area though allows for highway commercial.
So the sub areas are allowed in any district.
I understand that, but then you just said that the sub area then only allows for single family residential.
Correct. So the purpose of sub areas is to further restrict the zoning, right? So, the flum. I'm sorry, the flum. So if you have a flum, in this instance, that allows, restaurants and bars and everything else, but you only want to allow her to be able to do the vacation rental, this would be able to restrict that for you.
Okay, and so you could have the flum change in this instance and still have the R1 designation.
No, she has to change it to highway commercial.
No, but if, setting aside the desire for a vacation rental permit, with the existing structures that are there, I'm not saying it would be, why would anybody do it? I get it. But you could have a R1 within the mixed use 2 category.
No, so you can't have an R1 in a mixed use flum. You could have an R1 in the Winley Key, because the Winley Key no, actually you can't because it's the Winley Key mixed use area, so no, you can't. So you can't have an R1 in a mixed use flum. R1 can only be in the residential low flum.
Okay.
Isn't the property adjacent mixed use with R1?
Yeah, not with R1.
I believe, I'm looking at it now, too. Sorry.
Don't be sorry.
Unless, I don't know.
Hold on one second, sorry.
You asked the right.
Your public comment.
Can't do it.
Public comment?
Ooh,
I don't know if there is any, but.
public comment.
Oh, yeah.
I mean, I think a lot of this has to do with, again, wanting to keep parcels consistent without checkering all that zoning and flume by the zoning that we picked in the FLUM, it stays consistent of what's already starting to go from all those properties to the north side of me. And I think that was one of the reasons I had seek the professional consultant when we started this, and they had recommended stay consistent, and these two categories were compatible to achieve the vacation rental license, because they don't like seeing checkered zoning changes throughout the maps.
Process to amend, but when you purchased the property, you knew you were purchasing it as
Yes, ma'am.
residential.
Yes, ma'am.
We haven't done public comment yet. How about if we jump to
Let me
public
do it.
comment? I think Van has a word or two. Maybe just a word or two, Van.
Start the timer.
I want to make sure everybody's awake for this. If you're starting to sleep, wake up. I was on the LPA for 3 years and sat in that seat over there. And when I was on the LPA, Ty Harris was the planning director. And I watched Mark Gregg bulldoze Ty Harris into giving him 2 building permits for this property because it was on the highway frontage, and you can only build affordable housing on highway frontage. Well, it's not on highway frontage, it's on the old road. So it never should have gotten those building permits to start with. So it's a house built on sand. Those 2 building permits were supposed to be for affordable housing. That's how Mark Gregg got them. Now, Mark Gregg is his significant other is this lady's mother. And Linda is a beautiful, talented artist and a very nice lady. And this is a very nice lady here, too. But it doesn't excuse the backdoor way that suddenly they want vacation rentals on this property that surreptitiously, in my estimation, fraudulently misrepresented to get building permits to begin with. So in answer to your question, this was always designed to be vacation rentals from the beginning of this whole process over 2 years ago when I sat in your seat. And I watched it happen. And I'm not going to sit by and watch you guys at least have an uninformed opinion about whatever your decision is that you're going to make here. Because this is a house built on sand. It's not on the highway. It should never be highway commercial, because that's how they first got the 2 affordable housing permits. But they're not going to build affordable housing. They're going to build residential. Now they got the residential. Now we're going to do vacation rentals. And vacation rentals are a cash cow from now until the cows come home. Because, vacation rentals are $2,500 a night or $4,000 a week or and up. So these things are a long way from being affordable housing, which is how they originally got the building permits for these 2 houses. So if you want to reward that, you go ahead and do that. Thank you.
So Van, if they were deed restricted affordable housing, there's no way she could have gotten that built.
Well, I don't know how she got it built.
Well,
but I don't know how they got
changed.
changed. I don't know how the zoning changed either. But if you go back to the minutes of that meeting and look at that meeting and see how this happened, everything I said is stone true. And there's no doubt, and I don't know how in the intermediate, Mark Gregg is a lot of things, but dumb is not one of them. He is very sharp as a land use attorney, and this is his project.
Van, I will agree with you, because I had the listing on the property to the south of that, and at one time Mark Gregg was very interested in purchasing that lot as well, with the intention of increasing the entire parcel for to encompass basically 4 lots for workforce housing.
Exactly. And that's how he got the first 2 building permits. And Ty Harris signed off on giving him those 2 permits because it was on the highway. It wasn't on the highway, it was on the old road. It's I believe the stipulation is it has to be on US 1 for affordable housing to kick in. But they used that to get the permits because they fraudulently misrepresented the fact that it was on, not on US 1, it was on the old road. And now, I don't know how, whatever mystical, magical methods that Mark used, now suddenly we're here and he wants 2 vacation rentals. And I say to you, this was the plan from Jump Street. Thank you.
Just for clarification, these are not affordable housing permits that were issued. One was a market rate allocation that was given through the BPAS system, and one was an existing dwelling right on the property.
Thank you for clarifying that.
I'll be short. To point out the zoning change that happened beside our property, which is now the Hog Heaven parking lot, they had a single-family home on there that they demolished and they turned into a parking lot. It was a single-family home. I just went through, or not me, my person I bought the property from, on the property I own next door, just went through BPAS and got a single-family house permit. These 2 are no different than on each side of it that had a single-family house permit. And one of the properties that he's referring to, which I'm applying for the zoning change on, had a cistern in an old single-family structure on it. So to say these 2 properties got permits illegally or fraudulently is obscene, because they went through the exact same process as both houses on each side of it. So I don't see where any misconfusion could possibly be there. And I find it very offensive to be saying that this is a plan from the start, or even to say this is Mark Gregg's doing. Yes, he is my father and I love him dearly, but these are my projects that I have done and worked my butt off on and have absolutely no affiliation with Mark Gregg at all. They are 100% me, and I'm very proud of them, and I don't want any confusion there that has anything to do with Mark. I'm sorry. I don't like it when people throw him under the bus or talk bad about him, but these are my projects 100%. And every idea or any action is by me, no one else. These permits were achieved perfectly and properly as anyone else around us who waited in line and followed the right rules. Thank you.
Thank you.
I'll sit down.
All right.
Jocelyn, I hope you understand. I was not saying that. I know that during the conversations that Mark, when he was trying to obtain those properties, that's... okay.
All right. So we've had public comment. We've had some discussion here. We're down to probably a motion.
Motion.
Cheryl, was that you?
Yes, I'll propose a motion on the plum. Motion to accept as presented.
Okay, and this is on the Winley Cove property.
I'm sorry, on the Winley Cove property. Are we numbering these 1 and 2?
No, just say it's the Winley Cove property. We'll be okay.
Yeah, the other one's Winley Isles.
Other one's what?
The other one's called Winley Isles. So this one's Winley
sorry.
Cove, and you're making a motion for the flum as presented, right?
As presented, yes.
With
Winley
the
Cove.
correction, may I ask Jennifer if we need to say with the correction of 1 or 2, or do we need to?
I think that's in a recommendation.
Yeah, you can just say per my recommendation, because my recommendation is for...
Okay,
Okay.
per the
Modify
recommendation.
that to include per the recommendation of the planning manager.
Thank you. I'll make a second. Roll call, please. Oh, more discussion? I'm sorry. Roll call.
Cheryl Culberson,
Yes.
Deb Gillis,
Yes.
Patrick Foley,
Yes.
Tony Hammond,
Yes.
Lori Lalonde,
Yes.
Susan Raffanello,
No.
and James Ryan.
Yes.
Motion passes 6-1.
All right, now we're down to the zoning map change on the Winley Cove property. I need a motion.
Okay, move to accept the recommendation of the planning manager as to the zoning change on the Winley Cove property as presented.
Second.
I have a first and a second. Roll call.
Who was the second?
Tony.
Cheryl Culbertson,
Yes.
Tony Hammond,
Yes.
Patrick Foley,
Yes.
Susan Raffanello,
No.
James Ryan,
Yes.
Lori Lalonde,
Yes.
and Deb Gillis.
Yes.
Motion passes 6-1.
All right, now we're down to the Flume item for the Winley Isles. And it also needs to say with the recommendation of, well, I'm putting words in people's mouth, of
I can-
number 2, if that's what you want.
Yeah, I'll make the recommendation to approve as the staff recommends for Winley Isles.
Okay.
On the Flum?
Yes, we're on the Flum. I have a motion. I need a second.
Second.
I have a first and a second. Roll call.
James Ryan,
Yes.
Cheryl Culbertson,
Yes.
Patrick Foley,
Yes.
Tony Hammond,
Yes.
Susan Raffanello,
No.
Lori Lalonde,
Yes.
and Deb Gillis.
Yes.
Motion passes 6-1.
All right.
I can make the motion on the next one to approve as staff recommends for Winley Isles on the zoning.
Okay, I have a first on the zoning recommendation.
Second.
I need a, Cheryl, did you just second?
Yeah.
Yes.
Okay.
James Ryan,
Yes.
Cheryl Culbertson,
Yes.
Patrick Foley,
Yes.
Tony Hammond,
Yes.
Susan Raffanello,
No.
Lori Lalonde,
Yes.
and Deb Gillis.
Yes.
Motion passes 6-1.
All right, folks. We're getting down to the bottom of this. Unless I'm mistaken, we're done with the ordinances that we have, and does the chair or the local planning members have any additional info tonight? Hearing none. Future agenda items, planning director, village manager, or village manager. Do you have our next meeting dates?
I believe it's February 12th would be the second Monday in February.
February the 12th. And village attorney, do you have anything?
Nope, nothing for me.
I need a motion.
Motion to adjourn.
All right. We're done. Thank you. Good meeting.